Listo, salimos al aire en 8, 7.
Ladies and gentlemen, Colombia is currently the epicenter of observation and debate on transitional justice international experiences. During these 2 days, a group of guests from Argentina, Mali, Australia, Guatemala, El Salvador, Peru, Spain, the United States, Bosnia have shared and will continue to share the successes, difficulties, and challenges that transitional justice has faced. As well, the Embassy of Switzerland in Colombia welcomes you to the second international conference on the emerging atrocities to contemporary atrocities, sanctions and reparations for victims, social reconciliation, and institutional strengthening. We appreciate you connecting to this session from different parts of the world. Since we're in different parts of the world, we're just going to show you some instructions about listening to this virtual event in Spanish, English, and French. If you follow us from your cell phone, you can activate simultaneous interpretation by clicking on the three-dotted icon. You will have the option to show the menu with language interpretation, and you can select the language of your preference. On your cell phone, you can click on the Finish button at the top right, and you will have access to the selected languages. If you follow us from PC or a laptop, you can look at the control zoom bar and activate the interpretation module and select the language. That will be enough to listen to the session in the language of your preference. We invite you to join us in this conference through our social media, Colombia HEP on Facebook, HEP Colombia on Twitter, and HEP_Colombia on Instagram, and also on our portal, www.hep.gov.co. We will have open sessions and private sessions where your participation with questions or comments in the chat, as you did yesterday, will be an important part of this event. To continue then, we are going to give the floor and hear about the methodology and the tendencies of transitional justice peers and judges by Magistrate Marcela Giraldo and Heidi Baldosea. You're part of the organizing committee of this event. The floor is yours, magistrates. Well, good morning, ladies and gentlemen. I am just going to give you a summary of one of the panels that we held yesterday in the private session of this meeting. The panel was about remedy, sanctions, and reparations that have been foreseen and enforced in transitional justice scenarios and cases in the past as well. We had guests that told us about experiences from different countries. We also had information about the transitional justice process in Mali, in El Salvador, in East Timor. And we also summarized the historical conflicts and the political situation in these countries and how they have enforced transitional justice in these locations once they have reached peace accords, which institutions have arisen from disagreements, and what have been the challenges that they have adopted. When we referred to Mali, the president of the Truth Commission told us that in his mission of talking to the victims and understanding what they expected, they traveled to different regions in the country with mobile equipment and teams to ask them about the expectations and what they were expecting. And the victims said that they wanted to know the truth and they wanted to have reparation methodologies, and the commission made sure that it was the case. They had public hearings which were broadcasted on different TV channels so that the country would be aware of the violations committed during the conflict in Mali. And he also told us about a draft bill that they presented to give a response to the reparation requests submitted by the victims. So in the case of East Timor, Patrick Burgess, who was the president and the commissioner of the Judicial Commission in East Timor, told us about the experience in this country and the armed conflict that they had experienced. And he also told us about how they had developed a transitional justice system, a parallel system, parallel to the mixed court that was judging crimes against humanity. And this parallel commission was taking place in the communities with the perpetrators who were the people responsible for the most representative and severe crimes. So he told us about how this process had tried a large number of people in search of their social reintegration so that they could become part of society again and that they could respond to the expectations of victims and to give a response to the crimes that they had committed. In his recommendations, he also mentioned something that I wanted to highlight here. He said that normally what we could do is much less than what we would want to do. And he invites us to focus on the practical aspects of the jurisdiction. What do we want to do? Also considering the time and the capacity that we have for it. Then we also talked about the situation in Guatemala. A judge from the First Circuit Court in Guatemala, it is Yasmin Barrios, told us about the situation in the country. And she explained how transitional justice had been a significant contribution to the strengthening of the rule of law in Guatemala and to guarantee that victims would have access to justice and to have their rights respected. She mentioned some positive standards that we should consider in our mission as a jurisdiction, which was the implementation of international standards and judging within reasonable times, and also to have several opportunities so that victims could embrace their emotions and share experience, and that we should have experts of different disciplines that could actually complement the judicial role, and that we should focus on revealing the truth. That was the most important aspect to be able to implement transitional justice, and that we should continue focusing transitional justice on, or she said it from a transformational perspective, so that victims would not just return to a that they would not to the state that they were in before, but that they would have a state that was better than the one that they were in before. And then we had two additional presentations where the commissioner of the National Commission in the search for disappeared persons in the context of armed conflict of El Salvador, Leonora Artiaga, we also talked about the historical conflict in El Salvador and how this conflict took place and the time in which they reached a peace accord with the different groups. And she explained how these peace accords did not consider the needs and the expectations of the victims. So the commission gave two important recommendations to make changes in the judicial system of El Salvador. And they were also recommendations related to repression. However, subsequently, they issued an amnesty law, which was rather broad and did not focus on the search of the disappeared persons, nor on the indicators recommended by the Commission. So at the end, between 2012 and 2016, they started to create transitional justice institutions like the one that she works in, the Unit for the Search of Disappeared Persons. And this has allowed El Salvador to face what has happened in the past and to search for disappeared persons and to offer reparation to the victims. And to offer reparation to the victims, and finally, to respect the agreements reached in the peace accord. In her recommendations, she also said that the world is paying attention to what the jurisdiction accomplishes, and we had a responsibility ahead of us because we are evolving in law, and what we do here will have an impact in other transitional justice cases. And finally, the president of the Inter-American Human Rights Commission explained how in the Truth Commission, no, sorry, how in the Inter-American Commission, there is a large amount of information that could be useful for our work as a jurisdiction, which is related to the reports and amicable cases that do not reach the Inter-American Court, and we could find many standards that could be useful for us to implement in our work. She also recommended that it's important that we listen to the different organizations, that we should keep our open minds to these different perspectives, and that gender focus is also important to be applied in all cases of crimes against human rights and not just in sexual violence crimes. This was pretty much a summary of the panel, the first panel yesterday. Thank you very much, Marcela. Once again, I also want to greet all the participants who are joining us today. In the second panel yesterday, and also in relation to the current state of the implementation of the remedies that have been foreseen. In the final peace accord for Colombia, we had the intervention from the different components of the comprehensive system for reparation. These were the people who were working in the context of armed conflict. The commission, the Truth Commission, coexistence and non-repetition, and the special jurisdiction for peace. Dr. Luz Marina Cifuentes, the director of the unit for the search of disappeared persons, she told us about the component of this extrajudicial component in the direction and the coordination in an autonomous way to the judicial work in the search for people deemed disappeared with a purpose of alleviating the pain and the suffering of the victims and the contribution to truth, justice, and reparation, and the guarantee of non-repetition. She also reminded us of the importance of the participation of the victims in relation to their expectations, but she also highlighted their knowledge in the processes of search and finding. She also mentions the structural issues related to the understanding of this disappearance issues and these effects. And she also addressed the topic of who, where, how people meet their roles by showing instruments such as the record of people deemed disappeared in the context of the conflict, with a number close to 100,000 records, the National Registry of Mass Grave Cemeteries with more than 4,000 potential sites for dumping bodies, as well as the national and regional groups for search. And Commissioner Carlos Martin Berister also mentioned as a contribution to the Truth Commission, in addition to the report itself, about the existence of processes consolidated by the participation of the victims that could make sure that the remedies are complete and in full alignment with the social expectations and the institutional possibilities. But above all, that these remedies need to make sense for the victims. The commissioner also reminded the relevance of truth as a restorative measure, because he pointed out that it doesn't just determine the levels of responsibility of the parties, but it also allows us to understand the pain and allow restoration, which was fragmented and fractured by conflict. The commissioner also warned about the need for follow-up mechanisms in the implementation of the remedies by reminding us that sentences or indictments are only half of the way that we need to go through, because we understand that there need to be positive effects, restorative and constructive effects. The commissioner also points out the need of true monitoring effects that allows us to strengthen the recognition of responsibility and the impacts that also help in the insufficiencies, such as public policy for reparation of the victims, as well as the promotion of community restoration. The special jurisdiction for peace, also through the president of the chambers of justice and the rapporteurs of the cases of one of the subcases, case 003, with the presentation of the Chamber of Justice, they told us about the materialization of the legal competencies of this component, as well as the challenges that they face. The Amnesty Chamber, for example, told us about the compliance with their mandate based on the harmonization of principles, such as being centered on victims. And she also mentioned about the future activities that they have aligned related to non-prioritized cases, the openness to pedagogical spaces to the participants, as well as concentrated hearings. On her part, the legal case chamber noted the roles of this chamber in the sense of submission and the granting of professional benefits, the monitoring of the conditionality regime, and the acknowledgement of non-sanctionatory regimes. They also mentioned the broad universe of parties or perpetrators that require judicial responses because they are in their capacity of non-participants, and they mentioned the short and medium-term consequences of this. And finally, the judiciary of the First Circuit Chamber told us about how over the course of the years they have fulfilled their duties from based on dialogue and contextual and interdisciplinary participation through the dimension or new dynamics such as the submission of reports and also the dialogues to create truth, acknowledgement, and the construction of tools and restorative tools with a territorial and differential approach. They also mentioned about the compliance with the goals of a transitional justice model with specific acknowledgement of the truth and the rupture of negative or denying speeches, as well as to adopt the impacts of violence, not just from an individual perspective, but also from a macro and collective perspective. They reminded us of the restorative processes of this chamber from the beginning, as well as the contribution in the description and even the explanation of macro criminal phenomena, such as the body count policy tied to incentives such as case 003 and the participatory construction in the proposition of sanctionatory formula, among other aspects. So then we will start the sessions today once we have reported the summary of the activities yesterday. Thank you very much. Thank you very much, dear magistrates, for that wonderful summary of the session yesterday. We would like now invite Magistrate Cifuentes, President of the Special Jurisdiction for Peace, who is going to send a special invitation to the contest that they have. Thank you. Good morning, ladies and gentlemen. We are certain that this session is going to be similarly fruitful as the one that we had yesterday. It is my great pleasure to announce, as part of the pedagogy activities at HEF, I want to announce the launch of the university contest organized by HEP. This is a project promoted by the presidency and the Office of the Rapporteur at HEP with the valuable contribution of El Rosario, La Sabana, Los Andes, and Del Norte universities. The purpose of this contest is to foster the knowledge, especially for the students of law and university professors, in the mandate and the work of the Special Jurisdiction for Peace. Through this contest, we also want to create awareness in the academic community about the importance of transitional justice mechanisms in the construction of peace. The focus of the contest applies to purposes. It's an academic and a practical purpose. On the one hand, we intend students to learn about how HEP works and what is the applicable law and the jurisdiction behind it. And on the other hand, so that the students can apply their knowledge in a hypothetical judicial proceeding. And it addresses the most current challenges and complicated challenges of the jurisdiction. Of course, this is a judicial simulation contest consisting in participants assuming a role of representing one of the parties involved in a judicial proceeding, a theoretical and hypothetical proceeding, and they will present written and oral declarations in simulated hearings according to the role that they're playing. In this case, we are simulating one of the proceedings at HEP, and this is based on a fictitious case where the parties will analyze evidence, they will present arguments, and they will defend their posture.
We hope that this call would be an institutional input for also transitional justice and with the support of all the magistrates of help, and that hopefully it can be celebrated every year. In this first edition, the court or the chamber that would be in charge is the sanctions and indictment ones. But as the objectives are so diverse, hopefully we could simulate other proceedings in the future calls among other chambers and sections so that the learning experience can be more complex, plural, and diverse. So this call would be the scenarios so all students of law programs can learn from the different legal proceedings that we adopt every day as judges, as representatives of victims, and all appearing parties and all the other individuals that participate in proceedings of the HIP. We hope that on behalf of students, you can really engage in the transitional justice system, that you can develop skills on arguing, debate. Transitional justice, specific related topics that you can deep dive much more into the macro cases in international humanitarian law and international criminal law. And I believe that this call can certainly become a think tank for future attorneys that can work with commitment and passion for justice building and peace. And for this reason, we want to thank the universities that jointly with the team of the HEP worked to be able to create this call. And in this context of this very important conference, we want to officially launch the university call from the HIP. As of today, all general information and agenda of the latter will be published, and the exchange of knowledge between students and the Special Jurisdiction for Peace, I believe, will be very enriching. And that is why we invite all universities of the country, your teams, and members to actively participate, and all magistrates and professionals of the Special Jurisdiction for Peace. Well, you will have the opportunity to also become judges of the call, but also we'd like to motivate you to engage in it and participate. Thank you. Thank you, Mr. President, for this invitation to this university call of the HIP. You're all formally invited to consult all the information and the agenda related to it in our website. Now we'd like to start on a balanced comparison on remedy, sanctions, reparations. What are the outcomes created, the results, and also what are the proposals to advance and to treat these topics? As panelists, we will have now the leader, Fernando Travesi, Executive Director of the International Center for Transitional Justice, or ICTJ for its acronym in English. He was also part of the UNPD, not only in Colombia, but also in Tunisia. So we'd like to warmly welcome, and he was also regional director for the Balkans in the Movement for Peace. And aside from these, he is a renowned playwright and writer, and also winner of the National Theatre Award from Spain. So we'd like to welcome, and we will also have Carl Stauffer. He is senior expert in reconciliation for the Peace Institute of the USA. He is a strategic leader with over 30 years of experience in different peace, justice, and reconciliation initiatives. During his 16 years of experience in Africa, he worked in peace agreements, election monitoring, ex-combatant reintegration, collective trauma recovery, remembrance, deliberative democracy, security sector reform, as well as humanitarian and development interventions. His research focuses on restorative justice as a social movement and the use of indigenous and community justice as well. Justice practices as well. We also have Amir Zengic. He is a Bosnian professor, expert on transitional justice issues, legal advisor of the Organization for the Prohibition of Chemical Weapons, manager of the Organization for Security and Cooperation in Europe in Bosnia and Herzegovina. He served as well as a legal officer at the International Criminal Tribunal for the former Yugoslavia. for 12 years. He has been invited to universities of the Netherlands, Bosnia, Herzegovina, Austria, Latvia, North Macedonia, and other countries. We'd like to welcome you as well. We also have with us Naomi Rotariagasa. She is an American lawyer and professor expert in transitional justice issues, expert in transitional justice, international human rights law, and international humanitarian law. She has vast knowledge and experience in post-conflict processes in Latin America and Africa. Is also part of the Due Process Foundation since November of 2012, and also president of that organization since May of 2013. During her long career, she has contributed to the defense of human rights through legal support to social sectors, university seminars, as well as academic production. And the moderation will be in charge of Alexandra Sandoval Mantilla. She is VP of the HEP of Colombia and magistrate of the Amnesty or Pardon Chamber of that same corporation. Magistrate, please take the floor. Good morning, everyone. Thank you for this opportunity. I'm absolutely thrilled to be able to moderate this panel with these very important and interesting panelists that we have today with us. And in this topic, which I think is absolutely fundamental for the HIP, such as being able to have a balance, or what we call sanctions, remedies, and reparations in diverse parts of the world, and with the objective of providing feedback, knowing and being very much aware that the restorative system and the own sanctions that were installed in the HEP are unique. However, international experiences and what has been learned in other regions of the world can certainly help us to establish it in the best way possible. So I won't take too long because I would like to hand the floor to our excellent panelists here today. I'd just like to remind all panelists that you each have 15 minutes to present, and you will have a clock to be able to be aware of time, and I will certainly remind you when you have 1 or 2 minutes left. So we'll start by handing the floor to Mr. Fernando Travesi. Please take the floor. Hello, thank you. I will try to not speak so fast as I keep in mind the interpreters, and thank you very much for this invitation. It's always a pleasure to work and participate with Colombian institutions, specifically in the defense of victims, rights victims, and justice. So it's a pleasure to be here. So personally, as well as the organization that I represent, the ICTJ, we are fully committed in supporting as much as we can. So I will intervene in those 15 minutes that have been assigned to me, that I hope can contribute to this conversation. Firstly, I just want to present some general ideas on restorative justice and the links that it has with transitional justice, which I think could be interesting and perhaps feed the conversation. And then I will refer to some international cases that I deem could be also enlightening for the conversation, an example from Tunisia, Sierra Leone, and Philippines. But firstly, I'd like to mention that restorative justice and transitional justice are, I think, very closely related fields. They arise and they develop fundamentally to respond to the limitations of ordinary criminal justice. Restorative justice arises to basically respond to the limitations of justice or retributive justice systems in national trials. And basically, it switches, or rather adds more focus on, for example, the role of the victim, of the sanction, or of the sentence. And transitional justice basically makes a similar evolution, and it develops itself to respond to massive human rights violations in contexts where institutions of the rule of law are inadequate or inappropriate to basically manage justice, be it because they don't enjoy legitimacy or credibility due to the impact of conflict, or because they are perceived as part of the conflict itself, even as representatives of part of the conflict. That is why these two frameworks actually overlap in practice, because these two basically highlight similar values, such as the value of truth, the experience of victims, also accountability, reparation, resolution of conflicts with the participation of victims, and also accountable parties of violent acts. And these both create inclusive frameworks and not adversary frameworks that seek to reveal responsibilities and also avoid the past to repeat itself. And that is why these overlap quite frequently. These both have as a main objective the acknowledgement of the victim as a subject of and share and holder of rights and whose rights have been violated. And I think transitional justice, as you well know, the pillar of this is basically accountability. Accountability by perpetrators. And here we're talking about a more general accountability of responsibility, regardless of the assumptions of criminal law, regardless if, for example, accountability has been appointed by a justice or a justice institution. This is an accountability that basically levels out the power level between victims and perpetrators and allows a restorative dialogue between these parties. And that is exactly why I believe that these two have the same ambition, actually. And the principles of restorative justice have been applied quite explicitly in the non-judicial mechanisms of transitional justice, especially in the truth commissions and reconciliation commissions. One of the main reasons that I believe I could explain this is the trend that exists in most non-Western societies to make equivalent the concept of justice to legal and justice proceedings, to manage justice, and to reduce quite frequently the fact of managing justice with just penalties, sanctions, and punitive decisions or proceedings. And restorative justice actually is here to question that retributive focus and actually proposes more innovative practices to treat crimes in a different way. And this has also been proposed in criminal proceedings within the transitional justice context, meaning where there is mass violations of human rights that must be resolved. And this debate, as you are seeing, or promoting quite accurately between restorative justice and the alternative sanctions that up until now had been set out in different forms, is now having much more relevance, and it's actually interlinking at a national and international level. I want to just be very clear, meaning judicial proceedings in the context of transitional justice that have a more explicit and restorative justice statement are quite scarce. However, I do believe that there are some of these mechanisms that might offer content for reflection. And I think these are scarce. I think Colombia's case is excellent, where we see in processes of transitional justice a focus of restorative justice included, integrated in a much more articulated manner. As I've said in other contexts, it does occur in a clearer manner and perhaps in a more organic way, for example, in truth commissions. And the Truth Commission in Colombia has also developed different strategies to engage dialogues and encounters public acknowledgements of responsibility and accountability with participation of victims and ex-combatants, etc. But the special jurisdiction for peace is much more novel when we talk about combining this mixed or combined system of restorative and transitional justice that acknowledges the importance of victims above the importance of perpetrators, acknowledges a public statement of responsibility, and therefore also affects the concrete sanctions that we're all familiar with. In my opinion, I think it's important to just pinpoint some aspects that show the importance of these principles. Firstly, revealing the linkage between micro and macro. I think that the macro cases of the special jurisdiction for peace have been quite key for this, between clarifying the level of individual crimes of the victims and also the patterns of the more criminal politics. This is a linkage that is established, and to a great extent, it is due to being able to listen to the narratives of victims that not always have had the floor or have had their voices raised and that are quite complex. And another point that has been also proven by the special jurisdiction for peace is the great value in the public restoration process that fosters acknowledgement and empathy towards victims and all actors involved in these crimes. So we as an organization, and with the objective of gathering data and offering a deeper analysis of the development of restorative justice in all these transitional justice processes, we're carrying out an investigation, basically seeking other models that have included these explicitly in principles of transitional justice proceedings, in restorative justice proceedings, or that have perhaps been applied or translated in practice. And I will just mention 3 cases: Tunisia, Sierra Leone, and Philippines, as I just mentioned in one moment ago. So in Tunisia, well, I I don't want to lose sight of the context, but the familiarity, I don't know how familiar you might be with the process. So basically, in the Truth Commission, and it's called actually the Truth and Dignity Commission, there was an arbitration chamber established, and there restorative justice proceedings were applied for cases that were only solved by one special tribunal for peace. Just give me 1 second. I apologize. I apologize. I wasn't being able to see my notes. So I just mentioned that in Tunisia, the Committee of Arbitration and Reconciliation of the Truth Commission was another very interesting example where restorative justice principles are applied to cases and matters that are resolved solely, in general terms, by justice tribunals or courts. So in practice, sadly, the committee basically lacked surveillance and transparency, which was basically affecting irremediably its credibility. But as an idea, it was incorporated within the transitional justice law in the year 2013, and it proposed an arbitration process in which the actors of violations of human rights, as well as corruption crimes, they could acknowledge and be accountable for their responsibility and actually request the arbitration committee to resolve their cases between an agreement between the author of the crime and the victim. In many cases, the victim was the state itself. For example, in the case of of corruption crimes due to the huge corruption networks that appeared, especially during the authoritarian regime in Tunisia. This arbitration committee had to be complemented with a dignity fund, which is a fund that was created with a reparation vocation. It was a program for reparation that would fund it also by the assets delivered during the arbitration proceedings. What happened practically was that the arbitration process was quite problem because the number of cases that it received and on which it could work was very limited. It basically lacked surveillance, transparency, and it had a lot of due process problems. And it also had incapacity basically to follow regulations or international standards, also due to some ethical problems in relation to some of the cases. And although this arbitration process would reflect the principles of restorative justice, as, for example, the acknowledgement of responsibility and also the acknowledgement of the crime with the participation of victims and perpetrators, the process at the end did not work. And it ended up basically separated to a national policy, manipulating it itself by using it as a limitation of responsibility. And this committee could not also advance due to the fact that in parallel, very few advances were done in the systemic framework of the country that should have been done at the legislative framework, economic and social framework as well. However, it's a very interesting experience to take into account and to learn from it. In Sierra Leone, I would just like to briefly mention, being aware of time, the notion of restorative justice was not fully applied. However, the interaction between the different processes of transitional justice, the special court, the Truth Commission, these all reflected, without a doubt, these principles that I just mentioned. Also, in a cultural and social context that is much more receptive to this concept of justice. The Truth Commission, for example, provided in the year 2013 platforms so that the victims could participate, as well as the authors, with members of communities. And at the end of the day, it included in public hearings, for example, ceremonies where actors were accountable and were actually requesting or asking for pardon. And outside of the commission, other local actors, such as, for example, civil society organizations, religious organizations, and others, developed a very key role when facilitating engagement with the community. especially the integration of ex-combatants into the communities, and also the engagement between victims and actors of these crimes. These alternative mechanisms of conflict resolution in the long term were actually part of the decentralization of the security mechanisms recommended by the Truth Commission. And these have, in time, promoted a collaboration system of all the different parties of the community that are involved in, for example, violence events related to wars and other events. So these have created a system of conflict resolution with these principles that are now part of the social spectrum and all of the formal and informal institutionality. I insist, all this has been done without an explicit integration of the restorative justice principles that could have done all of these approaches much more coherent, and it could have certainly helped the integration of ex-combatants, specifically so that these could have had a more active role in the process.
I want to mention a final example because I have presented it in a general manner. I want to mention the case of the Philippines, the Transitional Justice and Reconciliation Commission of Bangsamoro from 2016 to 2017. They do not frame their work within restorative justice framework, but they reflect their principles and practices clearly, and it designs a listening process as an inclusive dialogue method, very extensive, in order to allow the members of the community to narrate about their collective experiences and their stories. And this listening process is also based on cultural and traditional processes of telling the truth amongst the indigenous communities. And also, the conflict resolution focus is based on the dynamics between victims and perpetrators with the purpose of restoring relationships. I think that this is an important point to be highlighted. And this assumes many resources and time invested in the preparatory processes. I believe that Colombia has proven that it's also very useful, and in an intensive training of the facilitators. In the case of Bangsamoro, these were people with whom the participants in the community could relate to directly and that already had some credibility in front of them. The Commission, by using these practices for the implementation of their mandate, recommended at the same time that these types of practices should continue to be supported and that they should be granted more social space. And this allowed them to continue with other programs and processes led by the civil society and local society, just as the case of Sierra Leone. In my opinion, just to conclude with some general ideas, these experiences suggest that restorative justice can be integrated more explicitly in the formal institutional spaces, and the government can take the role of guaranteeing the necessary conditions and the ideal spaces for the efforts that need to take place at the local and community level. There's also demobilization and the reintegration of former combatants. It's a perspective in which the lack of restorative justice could make communities feel excluded, and therefore they have to be connected in a clear manner in this debate. I think that I just want to conclude with a couple of ideas. These cases show that the principles of restorative justice can be part of the response to mass crimes against humanity. And they can be done in different ways from the institutional and national level all the way to the least formal and local level. And there are opportunities and great reasons to integrate restorative justice into transitional justice by highlighting the main contributions and establishing these connections between the micro and the macro level of society, and highlight the value of a public process in the need for transparency. And above all, the role of preparation, the training of these trustworthy facilitators, and the role of the government at the time of guaranteeing the space for these efforts. So I would conclude here. I have 2 minutes left, but I think I want to conclude here. And I'm sorry to the interpreters for the speed that I have given my presentation in. And I hope that my general contributions have been useful, and I am anxious to hear my colleagues in the upcoming debate. Thank you very much, and thank you very much for staying on time, especially for telling us about this tight relationship that we're also working on between transitional justice and restorative justice. I believe that it's very useful for us as a jurisdiction to hear that this relationship effectively exists. We had many questions about how to manage this in a macro level and to deal with restorative justice, because the examples that we normally have are from implementations in smaller scenarios. So everything that you just told us right now give us many ideas and a great deal of information that will be useful for us. Before I give the floor to Professor Karl Stauffer, I would like to tell all participants that you can submit your questions in the chat option of this event. And depending on the time left, we will ask those questions. So I want to ask you to please submit your questions in the chat and let us know who the question is addressed to. Professor Stauffer, please, the floor is yours. Professor, the floor is yours.
Thank you very much. It's a real pleasure to be with you and to be with my esteemed colleagues for this morning or this afternoon, wherever you may be coming from. It is indeed a pleasure to have this conversation because I think it is such a critical conversation. And I will delve right into the conversation so that I can make the best use of my time, and hopefully it will complement my colleagues on the panel also. So I want to make a few premises that before I go into my presentation. I come as a practitioner as well as an academic, but I have spent 20 years in the field. And so I'm going to draw from the practice as much as possible, with the hope that even though I am not a trained magistrate, that you can begin to think about some of the framework around practice as you think about the restorative remedies that and sanctions that you'll be looking at. And so what I'd like to do today is talk a little bit about framework. What is the broader framework in which restorative sanctions may lay? And the second is to look at some critical questions of restorative justice that I think need to be answered when we think about sentencing, restorative sentencing, or reparations or sanctions. The other is to look at key values and practices that drive, I think, a restorative approach to transitional justice. And fourth, what does it mean to meet the needs, which I think you have been doing very well with both the survivors and the harmed, and the survivors and the harmed doers. And I may get to some comparative cases as time permits. So I want to start by saying I do believe that restorative justice, I've been a practitioner of restorative justice since 1991. I see it not only as a social service or something that is a certain practice or skill set, but I see it as a social justice movement. We're seeing its application across many, many sectors in many, many societies. And so I believe, in fact, it's offering an opportunity for us, and Colombia is providing that opportunity to pioneer restorative justice as not something just attached to the criminal legal system, but something for helping us to solve our conflicts as humans at all levels of society. I also want to say that I believe restorative justice provides a nice critique to some of the over-legislated aspects of transitional justice, and I want to speak to those in these practices. So let me talk about a framework, and here I offer a framework from a colleague, Simon Keyes, who, from some of his work, who has been studying and teaching and working and researching around reconciliation for many years. I really think there are three things that need to be addressed as we begin to think about this restorative sanctions and the context, dealing with as a healing justice. The past will need to be dealt with or faced. Will need to be engaged. The second is relations and norms. And I say reconstruction, this is the challenge with the word reconciliation. The relationship was never there. So in many ways, we are looking at conciliation for those contexts in which the parties to the conflict and to the past violence need to coexist together. And how do we build this social there? And then these words building a more just society, looking at institutional as well as cultural shifts that allow us to move from a punitive culture to a restorative culture. Restorative justice has critical questions, and I would encourage the magistrates to think about how, as we sentence, are we asking or answering these questions in our work. The first is what harms have occurred, and the use of the word harms is very specific. We're not looking at just criminal legal codes, but we're looking at violations of human relationship also. So when those harms have occurred, we know that those drive the survivors and their grievances. And so we need to address those. But each harm presents a series of needs, a set of layers of needs. And so we also need to hear those needs and try to address those. Then the third question is, whose obligation or responsibility is it to try to make right or repair as much as possible the harms and needs that have been identified? And when we say whose, we're not referring to specific individuals, we're referring to even institutions, governments, collective entities. Those are content questions. There are also process questions. Who are the affected parties? Usually the circle of affected parties is larger than the criminal legal system would make out to be. Second, how can we involve as many of those affected parties as possible? I realize this makes less efficient, but we know reconciliation, the restorative process, will be in the future. And then what is the best process to design to meet these harms and needs identified? Now, of course, you as magistrates are not the ones who are going to be doing the process. You're leaving that in the hands of others. And yet you need to be thinking about who needs to be at the table to coordinate this effort in order for it to be holistic. So there are certain values and practices that are driving.
No sé si por traducción le podríamos indicar al
Professor Stauffer?
This process.
Professor,
Now,
we're having problems with your connection. You're cutting off.
Oh, my apologies.
No sé si pudiéramos hacer algo porque hay veces se corta.
Professor, your connection is cutting off and we lose your line of thought. So maybe you could try turning off your camera. That will help too.
Okay, let me do that. Thank you. Sorry for that. Can you hear me now?
Yes, we can, sir.
Okay, let me continue. Sorry about that. I want to move into what I talked values and practices that are driving our processes. 4 of those: inclusion. And as I mentioned before, research indicates that inclusion in peace processes, extensive research has been done with over 50 commissions, and to see which ones were the most inclusive and which ones were in context which peace and reconciliation was sustained for a longer period of time. And there is a direct connection between inclusion and sustained reconciliation or restorative justice. And counter, this is the need for people to come face to face across divisions and across separations and across polarization in order to understand each other, in order to face history together, in order to act together, and to possibly even heal together. Amends refers to reparations and the need for both material and symbolic reparations to be made. And reintegration, the really critical point of bringing people back into the human community, no matter what they've experienced as survivors of violence and those who have perpetrated violence. This reintegration is often a very material and symbolic process. But in our legal system and in the labels in which we sometimes work from a punitive perspective, there is little room for reintegration. And restorative justice says we must move from isolation to reintegration if we want to continue to keep social cohesion. In the sentencing, I think and the sanctions, we need to also think about the needs of both harmed survivors and harmed doers and offenders. So for the harmed survivors, they need safety and respect. They need information. What has happened? When did it happen? How did it happen? How is their loved one treated? They need to be given a voice to tell their story, sometimes public and sometimes in private. They need a place to publicly grieve. When I say publicly grieve, it's a place in which the community, the collective, the nation says what has happened to you is wrong. It should not have happened. And to grieve the losses that have occurred. They need vindication or satisfaction, a sense that they have been understood and that their needs and their harms will be rectified. And hopefully, they can move into the direction of healing and what many of the victims refer to as transcendence. Not closure, because they never forget what has happened, but transcendence, to live above it, to thrive. For the harm doer, due process is very important. Due process is, of course, a legal term that you're very familiar with, but the fairness in which they are treated. They need to be able to tell truth and give information with the hopes that we can raise an expression of empathy. Empathy is a critical science in this work, and the processes of restorative justice help us understand empathy. And what we do know from the science, the neuroscience, is that when some empathy is offered from one side across belligerents, the empathy on the other side usually raises. They need an opportunity to offer apology, to make reparations, sometimes very personal and very direct, and sometimes at a collective level. And they need their own reintegration and healing. In the last 8 minutes, I will talk a little bit of a few cases. Some of them overlap with the preceding speakers. Let me first of all mention Canada. Canada had a Truth and Reconciliation Commission for their Indian residential schools. This was over 100 years of schools run by churches and the government. These schools literally forcibly took children out of the First Nations communities and families and forcibly put them into schools to learn English or French and to change the way they dressed and to strip them of their culture and to try to forcibly assimilate them. This residential school settlement was in 2006. In 2008, the Prime Minister Harper of Canada made a formal apology. Also, the churches and social work organizations formally apologized. The agreement consisted of $2 billion in reparations to be administered by the government to those who were suffered and the 4 churches. The common experience, there was a lump sum of 10,000 paid to survivors and 3,000 for anyone who was in the school for 1 year and 3,000 for each additional year. The other interesting part of this agreement was an independent assessment process that set up additional reparations for those victims of physical and sexual abuse in these schools. They also did symbolic work with funding for healing and commemorative programs such as spiritual renewals, public education, the development of memorials and museums. They established a Truth and Reconciliation Commission with a 5-year mandate for survivors of the schools to tell their stories. This was both a way to give them voice and to educate the public. A second example I'd like to speak to is Sierra Leone. I know it's been spoken to. I come from the perspective of researching an indigenous process in Sierra Leone called Famble Talk. Famble Talk means family talk in their language, Creole. This was an informal, ground-up justice movement that doesn't necessarily use the word restorative justice, but is an indigenous process that has been owned by the communities and has been considerably less expensive than the transitional justice efforts. It has reached a larger group of people, and it has built social cohesion in very significant ways in Sierra Leone. I will say a few things. Not only has it helped many communities deal with the past and reconcile, but it has also built the social cohesion to increase the medical accessibility, to increase women in leadership politically at the local government level. The cohesion, the social cohesion was so strong in Sierra Leone that they were able to turn back and abate the tide of the spread of the Ebola outbreak. And lastly, right now they are talking with the government, and they have come into an agreement that the government has asked that the Famble Talk process be in fact the national approach to local development. These are significant, what I believe significant examples of transitional justice from an indigenous, localized level that moved up and have actually touched the national development and peace process. Along with that, Sierra Leone has offered a lot of survivors counseling. 16,500 survivors have received counseling. There's been an apology to the women. There's been a peace museum erected in 2019 in Freetown. And lastly, in the last few minutes I have left, I want to talk a little bit about Timor-Leste, which has already been mentioned also. Here we see a situation where grant pensions and other benefits to veterans of the independence movement were legislated. 12,000 people have been identified as beneficiaries under the scheme. As far as collective community reparations in Timor-Leste, recommended material reparations for communities seriously affected by conflict. There were symbolic reparations for victims, healing workshops for victims, apology from Indonesian and Timorese heads of states. There was collective reparations submitted by NGOs and the community, so they heard the voice of those most affected by the violence. And finally, they held healing workshops that provided communities opportunities for trauma healing and recovery. They set up survivor self-help groups and commemorative events, including the provision of tombstones for victims' bodies. However, only 417 survivors, in this case, have had access to psychomedical care. And this is very important. That number needs to be increased, as I believe trauma and trauma healing is one of the most critical baseline efforts that we need to give more attention to as we think about transitional justice and restorative justice at a macro collective level. I will end there, and thank you very much. I look forward to the conversations that follow.
Muchas gracias, Professor Stoffer.
Thank you very much, Professor Stoffer. We apologize for the technical problems, but despite of this, we were able to follow the very interesting presentation that you just shared, and this certainly helps us to respond to the questions and also contribute to the reflections that we're carrying out at the Special Jurisdiction for Peace. I would just like to remind you that if you are interested, you can ask your questions through the chat. I'd like now to give the floor to Professor, and I apologize, I may be mispronouncing your name, Professor Amir Sengik, so that we can continue with this very interesting panel.
Thank you very much for inviting me, first of all, to this important conference. I'm very grateful for the opportunity. And I also wish to congratulate all those working for the Special Jurisdiction for Peace on your crucial work in your country, and to wish you much success and fortitude in contributing to justice, peace, and reconciliation in Colombia, and hopefully for setting important precedents and examples for the future and for the rest of us as well, for the entire global community. So good morning to you all, even though it's afternoon here in The Hague. A slight rectification. I'm unfortunately not, and maybe one day I will be a professor, but I'm very much a legal practitioner. And my contribution today will be from the perspective of somebody who is both worked as a lawyer at the International Criminal Tribunal for the former Yugoslavia for over 15 years in different capacities. I've also worked at the Organization for Security and Cooperation in Europe on a project aimed at improving war crimes processing in Bosnia and Herzegovina. But also somebody who experienced war crimes at a young age and had to flee as a refugee from Bosnia to the Netherlands, to The Hague, where I now live. So my contribution is also going to be maybe even more practical than the previous ones, but I'm very glad to see the diversity in the panels between the academics and practitioners, and hopefully we will contribute and be able to give you some ideas about what's going on around the world. So I have to say that I speak on my personal title today, so all of the views I will express are my own. It's one of the requirements of the organization that I work for currently. Now, so I will focus on the former Yugoslavia, and in particular Bosnia and Herzegovina. I will also attempt to speak slowly to give the interpreters a chance to breathe. So when I was invited to speak at this important conference, I had to think quite deeply about reparations, for example, and restoration in the context of the ICTY in Bosnia, because as you will see, it's actually probably what you will learn the most from me today is how not to do things. So at the ICTY, it was the first international court, as you know, since Nuremberg and Tokyo that prosecuted war crimes, genocide, and crimes against humanity. And it breathed life into this field that was dormant for many, many years. And it has a lot of achievements, a wealth of jurisprudence. It has led to a proliferation of international criminal courts and tribunals, establishment of the permanent International Criminal Court here in The Hague, etc. But one field where I would submit it could have done more is definitely reparations and restitution of property, for example, and compensation to victims. Now, looking at the ICTY statute, there is actually, and I was slightly surprised to rediscover this provision, there is a provision in that statute which says that in addition to imprisonment, the trial chambers of this court may order return of any property or proceeds acquired by criminal conduct, including by means of duress, to their rightful owners. As you can see, already the ICTY had only the opportunity to imprison. There was no possibility to issue other types of, for example, non-custodial sentences, probation. There was no death penalty, luckily not. I'll come back to that issue a bit later. There were also no fines except for contempt of court. But there was this possibility actually to order return of any property, and that is in the statute of the court. And then the judges also further clarified the mechanisms for this in their rules of procedure and evidence, which they adopted, and they allowed basically a trial chamber a court would need to find that a victim had lost certain property, and the trial chamber had to make a specific finding on that in a judgment. Following that, there would have been a special hearing on this particular topic, and Also, the court could also order freeze of assets or some provisional measures to happen before this issue has actually been resolved. So that's very important. This possibility was there. There was also even a possibility in the rules which went a step further, and it allowed victims of international crimes. So a victim in Bosnia could take an ICTY judgment with them to a court in Bosnia and say, look, I've been found a victim in this court and I seek compensation here. So this is hugely important. Unfortunately, this was all theoretical. And in more than 20 years that the ICTY has operated, and it has been succeeded by the International Residual Mechanism for International Criminal Tribunals, these avenues, these mechanisms have never been used. And this is a hugely missed opportunity. And that's why I'm very pleased to see victims taking a central role, or a more central role at least, or more important role in international criminal proceedings at the ICC, at the Kosovo Specialist Chambers, at the Special Tribunal for Lebanon, and all other international courts, and of course at the Special Jurisdiction for Peace. It's very impressive to see the hearings that have taken place with regard to false positives and also with regard to kidnappings. I mean, this was very, very impressive to see, and I wish we had something like this in the case of Bosnia and Herzegovina, and unfortunately we didn't. In fact, going back to this possibility of the court to pursue these mechanisms, there were actually victims in one case who actually wanted to have certain property recovered that was taken from them. These were women victims of sexual violence, and two accused in this case called Kunarats. There was evidence that they had taken valuables and money from these victims, but unfortunately this issue was not pursued. I do not know why. I can only imagine that it would have been extremely difficult for a court in The Hague to order all types of measures to courts in Bosnia and Herzegovina, which were sort of civil litigation issues. But considering that the ICTY had the backing of the UN Security Council, and all of its rulings were binding on all UN member states, it's, I have to say, unfortunate to see that this didn't happen in more detail. Now, moving on to the Bosnian State Court, the situation there, unfortunately, is also not impressive, although it is slightly better when it comes to these reparations for victims. Now, the state court in Bosnia and Herzegovina was created in, let's say, in 2005. It came into effect. It was initially a hybrid internationalized tribunal, so to say. There were panels of judges. Two of them were international, and then one was local for 2 years, and then they actually switched. So there were two nationals and one international on the panels. To give you an idea, this court has issued actually around 259 trial judgments since it started to work. This concerns 292 persons, but basically its numbers, its statistics are higher than those of the ICTY, so that's something to think about. The court is also much more affordable. Now, when it comes to victims and seeking their rights in this setting at the Bosnian State Court, they are allowed to submit what we call property claims. And these are enshrined in 4 criminal procedure codes which apply in Bosnia and Herzegovina. Unfortunately, Bosnia is a very divided country still to this day, and reconciliation has still a long way to go. And the division also means that we have a criminal code at the level of the state and criminal law at the level of the 2 main entities, let's say federal units. And then we also have a district which also has its own criminal code. But all of these allow victims to file a property claim in a criminal trial. Now, when that happens, the prosecutor has a duty to gather evidence in relation to this claim, and the court must decide on the claim and whether doing so would not considerably prolong the proceedings. Now, these claims can also be material, but they can also be non-material, such as emotional harm. Now, Unfortunately, there are some challenges with this in practice, as observed by the mission of the Organization for Security and Cooperation in Europe, which has a very important role in monitoring. And I think that's also a very good lesson learned. There is this independent international organization which actually monitors war crimes proceedings and issues important reports, and I would say holds in check some of the national actors. So I think that's a very important lesson. So the OSCE has people observing the actual trials who sit in the courtrooms and review files. And what they've observed is the judicial actors actually fail to inform victims of their right to file property claims. So the victims are not informed of this properly. So this is obviously a very big lesson. Make sure that the victims are aware of all of their rights. The prosecutors actually sometimes fail to gather evidence in relation to the claims. They're not prioritized for whatever reasons. They could be justifiable maybe, but they do not prioritize them apparently, which is a problem. And courts fail to adjudicate the claims when appropriate. Now, courts justify not doing so by saying that they would considerably prolong the criminal proceedings if they had to also examine all of these property claims or emotional harm claims, which is a little bit difficult to accept. And in some cases, the courts have claimed that the courts have stated that the claims are undetermined or imprecise. According to one study, there's only been in only 4% of the cases, there's been a decision on a property claim. And as I said, these numbers are still better than the ICTY, but unfortunately they're not great. And when it comes to these claims at the war crimes proceedings at the Bosnian State Court, these usually relate to victims of sexual violence, usually rape. The awards that victims get range between 5,000 to 20,000 euros, and in one case maybe to 50,000 euros. But then a problem that then appears is actually that sometimes the accused or the persons convicted who are supposed to pay this money do not have the money to pay. And the system hasn't really solved this problem. There was some talk of establishing a trust fund for victims, that they would get the money pending any resolution of claims against the convicted persons. But unfortunately, this hasn't happened. So even though there are some cases, this is pretty much a paper tiger. Now, victims whose cases are not heard at criminal proceedings actually can do civil proceedings, but this is with many, many problems, and in particular the problem of protective measures, because they would have to, once they go into civil proceedings, so outside of criminal proceedings, they have to identify themselves. Their identity will be revealed, and when you're talking about rape and these types of crimes, this is hugely damaging. So this is very problematic. And what could have the ICTY done differently? Well, for example, just to give you some food for thought, the Kosovo Specialist Chambers, also here in The Hague, have issued a decision in February earlier this year, where they asked 3 experts to tell them, can you please explore whether the Kosovo legal system is sufficiently robust? Is it realistic to expect them to award damages to victims of international crimes? So these 3 experts said there are many problems: corruption, length of civil proceedings, execution of awards that I just mentioned, no big trust funds, no possibility perhaps of money, huge problems. And the court actually then went to conclude, but relying mainly on the argument that victims' identity, the protective measures that the court assigned, that there's no guarantee that these can be maintained in Kosovo's civil litigation systems. So for that reason, they decided, okay, we're not going to let the victims of these crimes go to Kosovo to seek their justice. We are actually going to issue a reparations order. And for that, in order to do that, here are a number of steps that we need to clarify to do this effectively. So this court took the initiative basically and explored whether a country can actually provide reparation, and they concluded that at the moment this is not possible. So they took matters in their own hand. I think this is very commendable, and I very much look forward to see what exactly is going to happen in this case in the future. Now, moving on from reparations to sentencing, a lot to be said here. Again, from a court point of view, from a legal point of view, a very sort of classical approach. The ICTY has seen cases basically sentencing for retribution purposes, punishing the offender for criminal acts that they actually committed, and for deterrence, which is understood as preventing future violations of IHL. There are a lot can be debated about this, especially deterrence in light of what's happening now in Ukraine, but I think we can also look at deterrence maybe not as globally, even though I definitely think that some of the work done by the international courts definitely deters those who are thinking about committing crimes. They could end up in The Hague. We have seen many heads of state ending up in The Hague and facing justice. So I think it's still an important weapon in that aspect, but we can also look at it at the local level. For example, the ICTY received a lot of attention in former Yugoslavia, and anybody who would want to commit war crimes again in that place would have to keep in mind that they could end up in The Hague as well. Now, ICTY's practice with regard to sentencing in some studies has been found not to be entirely consistent, in others more consistent. What I mean is that, you know, the accused would get more years of prison than in other sentences. Now, victims have not. I mean, this is always a bit difficult. There's a whole scope of victims, but in general, according to some studies, victims have been dissatisfied by the sentences given by the ICTY. And here we can also, you know, think about a victim is never going to be no length of sentence will ever satisfy or remove the pain that a victim has suffered. It'll never bring the loved one back. That's never going to happen. But we have to also understand that for victims, the gravity of a sentence is a measure of whether the outcome of the trial is just, or of whether their suffering has been recognized. So if somebody gets, 2 or 3 years for murder, and then they hear in an American movie that somebody gets for murder, they get triple life and these things, then this is problematic to explain. So this is something to think about. Plea agreements also very important. For example, they are genuine. We had an example at the ICTY of a very prominent leader, Biljana Plavšić, pleading guilty and recognizing that she had committed crimes against humanity. Once she went through all the procedures, she actually took her words back. And while there was originally a lot of enthusiasm about this guilty plea and admission of guilt, she basically returned it, and everybody now thinks that she played the system and is unhappy about that. So if there are plea agreements, make sure that these are genuine to the extent possible, and that these are effective for both the victims but also for the person pleading guilty. One final thing that I'm going to mention is something regarding the sentencing, a very absurd situation also with regard to principle of legality at the Bosnian State Court. So the Bosnian State Court applies both the criminal code of Bosnia and Herzegovina from 2004 and also the Yugoslav code that applied in the 90s during the crimes. So what happened is that they sentenced those convicted of genocide, crimes against humanity, and war crimes according to the Bosnian criminal code, allowing them to issue sentences above 20 years, so 40 years, etc. Then one particular person complained about this, saying, no, you should have applied the old code from Yugoslavia, which actually contains the crimes of war crimes and genocide, and I should have received a sentence according to that law. And that law only allowed a maximum 20-year sentence for these crimes. So war crimes or genocide, maximum sentence 20 years, or death penalty, but death penalty is out, luckily. So the European Court of Human Rights, because Bosnia is subject to that, the European Court of Human Rights said that they are right, they should be receiving those lesser sentences. So now we have this absurd practice that if you're convicted of a war crime or genocide, the maximum sentence you can get is 20 years, because this was the sentence according to Yugoslav law. If you are convicted of crimes against humanity, you can get 40, 50 life. So this leads to a lot of, so it's important to think about principle of legality and what laws applied when you're talking about transitional justice and how to deal with that. Final point I wanted to make, and really the final point, is outreach, hugely important. The ICTY was late to reach out to the victims, to organize programs, to organize meetings with them. So that's cannot be underestimated, the importance of outreach to the victims and to the communities in your countries. I think I'm within the time, and I'll pass the word to Alexandra. And thank you again for having me, and I wish you much success, and also to the panelists. Thank you. Pleasure to being with you.
Muchas gracias por la presentación.
Thank you very much for your presentation. I believe that after listening to all of you, we see that there are best practices, but it's also important to consider the mistakes or things that haven't turned out correctly in other systems, and that could also provide us with tools to not repeat them. So we want to thank you for your presentation. And now I want to give the floor to Ma'am Naomi Roth-Riazas for her presentation. Welcome. Good morning. Good morning to you all. I also have a presentation that is rather practical, but before that, I wanted to thank you all for the invitation. As many of my colleagues have said, the work that you're doing in Colombia and this comprehensive system is very important in the sense that it's opening up paths to innovative and unparalleled methods. I think that, as my colleagues said, there are some experiences that could be useful. And I am going to talk about 3 topics. 1, non-prison sanctions. Secondly, collective reparation programs. And 3, I am going to talk about some practical aspects in the interrelationship between transitional justice and the creation and consolidation of a social rule of law. In the first aspect about non-prison sanctions, there isn't much to say. There isn't much practice. In almost all transitional justice systems that include a criminal component, they end up in imprisonment or in parole or in house arrest because of health or age restrictions. There are 2 examples. One would be East Timor, and the other one would be Rwanda. I am not going to comment much about East Timor because my colleagues have already commented about it, but for those of you who are listening to us today, there were some trials because of severe crimes, but simultaneously there was the process of acknowledgement, reparation, and reintegration in the communities and villages for less severe crimes, such as crimes against property and lesions. There was a 5-person panel organized by the Truth Commission with authorities of the transitional justice system, local authorities as well, and spiritual authorities, which is very important. And specifically consisting of women who listened to those who wanted to be reintegrated. And they agreed on reparation acts, including asking for forgiveness, offering animals, or working in the schools or in their homes. For me, an important aspect is that they used ethnic and religious traditions in these processes, combined with a formal agreement that will go into the justice system. The other case was Rwanda. In Rwanda, they arrested more than 100,000 people because of genocide and other severe crimes, and the prison sentence nor the judicial system was able to cover that amount. So they created community systems that were called gachacha, so that the affected community would hear cases being decided by a third-party panel who were trained, but they were part of the community. They weren't professional legal experts. And the sentences depended on the category of the crime. And also, if they had acknowledged their own responsibility before or after appearing in the list of alleged responsible parties. So there are some similarities with what you're doing in Colombia in the sense of trying to make sure that people do not wait to be tried. The medium level authorities who hadn't accepted their responsibility weren't part of the system, but they were part of the formal system, the government. And after these community trials, the government created a voluntary work program instead of or complementing imprisonment by means of a law which was called a general interest work. And those who undertook it were called tiguistas, and the program was called Tigi. So in principle, those who met these requirements could be part of a prison system, but then they changed this, and at the end they didn't send anybody to prison. They wanted to foster the reintegration and the rehabilitation of the detained persons and used their efforts for local development and, if possible, as direct reparation for the victims, for example, rebuilding their houses. At the beginning, the idea was that the people who conducted this community work would live in their homes, working 3 days a week, and then they could go back to their plantations and their activities. And the projects were going to be selected by the district authorities. But then it turned out that this logistic process was very complicated. There were problems with regional balances and who had projects or not. And to create projects that would correspond to the real capacities of the people and with the integration. The communities, many of them incorporated survivals of this genocide. Many of them were afraid of tiguistas because, of course, they had been the perpetrators. And the perpetrators themselves feared for their own safety or security in the villages because people didn't want them. Some survivors actually considered that this punishment was too light. And for the prisoners, they felt that this was forced labor, that it was part of a colonial inheritance of forced labor. So at the end, they changed the program to consolidate these community work brigades that would work on road construction projects, housing projects, ecological projects, and the manufacturing of bricks. But they lived in campsites and they would work 6 days a week for a shorter period of time. This means that the sentence was shorter, but it was more labor intensive. There was no restriction of movement. They were allowed to interact with their local communities and to go back and visit their families. And they also worked on different projects that would teach them skills to obtain a job later on. I must say all of this, that it incorporated a strong spiritual and religious work that would facilitate this re-encounter with the victims and to be able to blame the devil for the craziness that led them to commit these atrocities. I am not saying this because Colombia is similar to Rwanda, not at all, but I believe that there are some lessons to be drawn from this process for non-imprisonment sanctions that are being proposed in Colombia. So now I want to move on to the second topic. I want to change my perspective from perpetrators to victims. I want to talk about collective reparation experiences. As you know, transitional justice has promoted administrative reparation programs with large numbers of victims and communities who had been victims and survivors. They proposed that collective reparations, in addition to individual reparations, this is not a substitution of individual reparations at all, but they also need collective reparation because there have been damages to the social tissue that go beyond individual or family damages. And also because rehabilitation and reparation requires state resources that are easily or that are provided collectively easier. For example, access to food, to medical services, and others. And the debate has been up to what point should they replicate the efforts of the government, especially given the lack of presence of the state in the territories. The state should have built schools, medical centers, and to have assigned the necessary staff there, but they haven't done it. So this collective reparation is to replace the lack of presence of the state or to provide the victims what they have never had in terms of presence of the state or both. And part of the debate is whether they should propose doing what the state has not done, or should they add specialized collective services for survivors and victims. For example, specialized centers for torture victims, such as the ones created in Chile, which was called the PRICE program. And the intention of those centers was only to work with torture survivors and not with other people. And after some time, they saw that for these centers to have financial viability, they needed to work together with the Ministry of Health, which caused complications. So if it's only specialized services, they are at the risk of not being sustainable. But if they are general services, maybe they do not correspond to the specific needs of the communities of survivors. There are a couple of interesting experiences in Peru and in Aceh in Indonesia as well. In both countries, they try to formalize a process of offering a vote to victims in the sense of what type of collective reparations they wanted. In Peru, it was with a small number with that project, which were executed by the municipality, and the community would decide. That was the highest priority. And here I want to point out that the interesting aspect was the gender division in this process. Women wanted electricity projects, for example, for their children to be able to study at night, and men wanted more productive projects. So we have to be careful with these types of propositions because there could be a significant gender division in this sense. An example of the risks and potentials of collective reparation programs was the National Reparation Program in Guatemala. The idea was that they were going to offer individual reparations in a relatively small amount, roughly $5,000, and collective reparations with investments in health, housing, education, and others. So they also thought about specialized programs. For example, to recover and disseminate indigenous knowledge of midwives and herbal doctors to the new generations and include them within the medical services and incorporate them in a medical center, for example. But there were several issues in the execution. First, the ministries of health and education and others had very negative practices, starting from inefficiency, nepotism, corruption, taxes needed to be paid, and the discriminatory activities and attitudes against the poor, women, and indigenous communities. So if they only included people to the National Health Service, that wasn't a reparation, but it was another source of victimization. And secondly, it became a source of resources, and they actually used the resources of the international community for projects, but that was in the interest of the political parties and specifically the corrupt parties or those who were partnered up with organized crime. And for example, the housing programs were granted to the followers of the governing party, and the contracts were awarded in a non transparent manner, and so on. And this leads me to my final comment. I have time still. I want to propose this issue, which is a very practical issue, but I want to say this in a more general manner. How to work on reparation or reinsertion projects with public and private powers that are not used to working towards the public good or the common good of the population. How to do this without reinforcing local powers and bureaucratic practices that are excluding, racist, and corrupt. And those practices are very common. It's not just in one country, it's in all countries where we see this issue.
There are experiences even in Colombia, for example, development projects intake by corruption elements or organized crime that even create their own fake NGOs. This is not new, certainly. However, it's a problem that will affect the transitional justice program. I have some suggestions. One is to simply carry out the analysis, analyze in the execution of projects, the services, the programs, and review who should execute them, be it the municipality, the ministry, an ad hoc committee, a university, a coalition of NGOs, meaning how this should be done on the basis of a specific analysis of the area that can include analysis of the factic powers and also power relations, always seeking a transformative vision and not maintaining the unequal power roles at a local level that currently exist. How can we break that? And for this, you shouldn't work in silos. There are network and institutions, for example, academic institutions that are fully dedicated to understand these local networks of power in the context of other elements, for example, corruption, criminality, environment, work done with women, etc. So, secondly, how can we insist in the transparency of the acting of institutions, even financial transparency? There are experiences that are quite interesting. For example, not in the transitional justice field, however, in the field of, for example, the return of those robbed assets. For example, the case of Estinia Bacha from Nigeria, where a committee was created that had or was composed of civil society victims, the state, international community to surveil, evaluate, and publish and also seize the use of the assets that were used in projects of of the return of robbed assets. And just to close, a compared vision of the experiences of transitional justice can show us that many times the promise and the achievements of these processes fall short because prevention measures are not conceived in a sufficiently broad way. For example, and this has been already discussed at the beginning of this conference, it is not about only the reform of, for example, the security and public order forces, although this is a path that should not be procrastinated. However, we must think that the mechanisms of financial control, customs, communications, and the necessary change must also occur in culture and in the acting of certain organs of local power. It is therefore not about extending the tasks of transitional justice to the extent that it cannot do anything well and it just tries to solve all problems of the world. That cannot be done, obviously. However, it is about an exchange of ideas, of experts, an expert appraisal, of coordination and monitoring and joint coordination of all the different mechanisms that work in the transitional justice and system and in similar fields. I think my time is almost over, so I will close now, and I'm very much looking for your questions and comments. Thank you. Thank you very much, Ms. Naomi, Dr. Naomi, and I'd also like to thank you for all the examples you've provided. Up until now, up until this panel, I used to say that we have very low examples and references and that we felt very much isolated. But I think in each of these interventions, but especially yours, proves that there are not things that are equally the same. However, there are certain paths already walked and lessons learned that are certainly useful for the special jurisdiction for peace in Colombia and this application of restorative justice at a macro level, in macro cases and in macro cases of crimes against humanity. Now, we have some minutes to share some questions. I will therefore introduce one of the questions made by one of the magistrates of the Special Jurisdiction for Peace. And I'd like to ask you to please, from your field and knowledge, can provide a response for this question. This would be a 2-minute intervention for each, because this question is not addressed to any of you in particular. So the magistrate asks the following. In the case of, for example, war crimes, gross violations of human rights, crimes against humanity, is it sufficient, according to international standards, to provide only restorative justice for perpetrators that are not selected as those most responsible? This taking into account the international standards for the fight against impunity. And would you consider that it is admissible that there is not a minimum retributive sanction for them, meaning for those that are not acknowledged as most responsible, but that could be or could have been engaged in, for example, violations of human rights or crimes against humanity and war crimes? That is the question. I know it's a difficult and challenging question, so I don't know if one of you would like to start, or should I perhaps hand the floor to, why not as it was in the same order as you exposed? Fernando, you could, or I would like to answer rather. Okay, thank you very much. Well, I will speak about, or rather from the perspective of the inter-American system perspective, which is of interest. So the first point, as you well know, there's lots of jurisprudence on amnesties, and that amnesties and pardons are not admissible in the inter-American system. That's the first point. Now we have to say 2 additional things to this. Firstly, there is not much jurisprudence on sentences, nor in the inter-American system, nor in the global system either. There's a lot about research, trials, and types of penalties. But what type of penalties, that is not so much investigation. That has been basically delegated to each country's or state's decision. There are some cases that talk about proportionality of sentences, and that the fact that sentences must be proportional to the damage or the harm. But this is not quite explained. They just said proportionality, right? There's also a reasonable from the judge Julio Soria Bazan in the case of Mozote. Within the peace process in Colombia, this is a recent vote, and he says, well, an armed conflict is quite different to, for example, a situation of a repressive state such as Chile or Argentina. In armed conflict, there's much maneuvering margin, because what's at stake is peace, and peace is an important value. So these are basically the context that there is. So what I'd like to say is that still for the case of not of the most responsible parties, if there was just one sole decision that perhaps they are not going to be imprisoned, well, that would be problematic. Now, if this is an exchange, for example, them telling the truth, of them promising non-repetition, of them doing something for victims, or that they can provide full information, I think that certainly places us from another field rather than that full amnesty place. So I do think that there is a way of validating and monitoring that these conditions are really being complied with. Then I believe that that creates less problems from the international standards perspective. If it would just be like, all right, you do it yourself, that would be problematic. That would be my response. All right, thank you very much. I think that that's a very full response to a very challenging question. So I'd like to know if any of the other speakers would like to provide their answer. Yes, surely. I can continue, and I would add to Dr. Naomi's response. I think she has given a very full answer, but perhaps instead of complimenting, I would like to highlight that amnesties are legal and legitimate legal mechanisms. These are established very well in international criminal law, and each country, for example, Colombia, has shown its own experience, and it does it in a way, in a conditioned or not conditioned manner, through different processes, through different contributions as well. And there also other alternatives are provided rather to, for example, just imprisonment. And I think that this question is very specific, but it also leads us to the philosophical origin of what we understand by penalty or punishment, or what we understand by retributive justice. If the punishment is then compensated with, for example, imprisonment, or if we find restorative justice or transitional justice systems that can provide us alternatives. I think we might ask ourselves, what do we seek with punishment? What is the objective of punishment itself, of a judicial punishment? Are we seeking to sanction or penalize a behavior? And we need then to ask ourselves if the sanction of that behavior should be done through, for example, prison sentence, or are there other ways to, for example, punish that socially, morally, culturally, or ultra restrictions that are not prison sentence solely. And afterwards, we then go back to these principles that we just talked about that have been frequently mentioned. What is then the understanding of punishment from the victim's perspective? What do victims need for them to feel repaired and restored? Is it through a prison sentence? Yes or no? Only? Or what else is needed? And through those dialogue processes and listening processes and understanding of the different situations, for example, of victims, that is what provides the keys to be able to respond to this question. I do agree with Dr. Naomi. There is no jurisprudence certainly establishes certain frameworks, but there are not predetermined answers to this. And I personally am not so keen to just say yes or no, or good or bad. I think that these are very complex cases where we need to really break down what can be the most appropriate answer for the moment that can guarantee that the objectives that we seek of acknowledgement of justice, of reparation, of sanctioning can be achieved. Thank you very much for this compliment. Now I'd like to ask to our other two speakers if they would like to provide an answer. If not, we have other questions following up.
I'll be very brief. I hope that I understood the question correctly. But just to add to the discussion to what's already been said, and I think that's very interesting, especially from the philosophical point of view. I mean, we had this case in Bosnia Erdemovic at the ICTY where this person he pleaded guilty to killing 70 or 90 individuals in the Srebrenica genocide, but he claimed duress. So he claimed that he was told that if he doesn't do it, he or his family will be killed. He got 10 years in the end, but then that was reduced to 5 years in prison. he did testify against a lot of people afterwards, but a lot of victims were also shocked. They couldn't get the full picture, perhaps. The value of his testimony against other people who committed crimes, and the value of his guilty plea. But their view was, this person killed 90 individuals, and he's only getting 5 years, and then you serve 2/3 of the sentence and you're out. So they felt totally insulted. But again, it very much to what Professor Travesi was saying, I mean, the context, and every country is sovereign in its own right, and sentencing policies, especially the restorative justice, which I know little about, less about, there is no, for sanctions, there is no such limitations, I would say. So I'll stop there.
Sí, sí, entendió
Yes,
perfectamente.
you did understand the question. Thank you for that reply. I would like now to ask Dr. Stauffer if he would like to participate. If not, we would have extra minutes to perhaps cover one more question. So there is, I think, also another question that has been linked to what you've been telling us. All these different measures of restorative justice, together with some of the measures that we have within the special jurisdiction for peace, specifically for those most responsible. So we have a model of a restorative justice that is quite strong, that must be applied, but for maximum responsible parties, we will have what is, well, it's not exactly a prison sentence, but we have called limitation to freedom. So the question is, from the knowledge that you have and the experiences in which you've worked in, how do you deem possible, or how do you think that we can articulate these two types of measures to provide ultimately what is most important for the special jurisdiction for peace, which is a clear response to victims? So would any of you would like to start to answer this question? Perhaps Naomi, would you like to tell us something about this? Perhaps I'd like to wait, and I'd like to now hear my other speakers, because I feel I've taken.
I can add a bit to this, unless somebody else is very keen. I think that's a very interesting question, and we have to think out of the box. Now, I come from a criminal court in its classical sense, where you could only send someone to prison. But what does come to mind is sometimes we would get requests for provisional release of accused, for them to go attend a funeral or due to sick leave. And in one case, or if they would surrender voluntarily. And in one case, this Kosovar former prime minister, the limitation on him was that he could not participate in the political life, and this was important sort of to alleged victims and of his crime, so that he's not there in the public discourse, in public life, and not in their view spreading hatred and etc. It also makes me think about this law on genocide denial. There's a huge debate in Bosnia, actually, about this law. This exists in a number of European countries. It's very different to the freedom of speech in the United States. But now in Bosnia, we have this international representative who's imposed this law on genocide denial. So it limits people to deny that genocide happened and deny basically judgments of the court. But this is a bit broader and maybe more community-wise. But for limitations of freedom or other sanctions, what we also, in some of these provisional release decisions, like, do not go to certain areas, or do not discuss this, do not contact witnesses and victims, and things like this. Now, again, this is a thing that can go both ways. Just really thinking on my feet here.
Muchas gracias. Les pregunto.
Thank you very, very much. Now I'd like to ask if any other of you would like to perhaps provide more response to this question. Yes. In continuity with what Amir has just answered, I do agree that restrictions could be applied to other type of deprivations of liberty, for example, movement, mobilization liberty, economic liberty, and restrictions that exist in other fields of law, for example, family law, etc. There are other elements, I think, that could limit, or rather feed this and enrich this discussion. I believe that Colombia has, in this case, it has a lot of gained territory, which is the process that you've developed in the last years. So much dialogue has been carried out and so much conversation and exchange together with the organizations of victims, with the perpetrators that have participated and that are fully committed to the process. I think that provides certain possibilities. Although challenges are huge, I do think that this is the right direction to go to really restructure these in the right manner. I've worked for many years in Colombia, and now I've been abroad for several other years, and it's definitely evidence that progress is clear. Some things are happening that would have been unthinkable 10, 15 years ago, that we've seen, for example, in the public hearings with the Truth Commission, with those encounters, and with this acknowledgement of responsibility. And I do believe that that is exactly the key that will guide us to find what is the true limitation or restriction that can be more appropriate. And I think that Amir just said that at his end of intervention. What's most important is to communicate it and explain it in a very public and transparent manner, so that this also has a social impact that can sometimes fall short, which is much more appropriate, but perhaps does not have an approval of the whole society, and that I think is, or at least of the majority of society. And this is a topic that has so much to do with dissemination and communication. But I think more than what, it is how we get there to find the most appropriate manner.
Así es, el profesor Stoffer.
Professor Stoffer, I think you had raised your hand. Would you like to comment something?
Sure. Yes, please. Thank you. It does. In many ways, these questions are related to it. And I'm going to come at it from not a legal perspective, but more of a sociological perspective. But I think I like to move. I think we need to find bridging language between punishment and restoration. I think accountability is one of those words. I know that it's also a legal word, but I think it provides us with a more open to look at accountability being restrictions on, as the HEP has said, restrictions on certain movement or rights, but are not punishment for punishment's sake. And so with those, accountability can be defined in a more effective way. I would use that language over just punishment or punitive. And I think when we think about accountability, though, part of the challenge is the communal societies versus individualistic societies. So if it's an individualistic society, there's a sense of we punish one person, we focus on that person. And in communal societies, the idea is that we're all deeply connected. And therefore, we need to restore each other's humanity in community, even when there's been a great breach. And I think that's one of the biggest challenges that we have. It's a cosmology, it's a cultural shift, an attitudinal shift about our interrelation, our interconnection as human beings. But I think it's really important to ask the question, a very, very practical question. What has been the effectiveness of imprisonment, for instance, or incapacitation? Especially incapacitation without rehabilitation. In other words, if we're going to incapacitate, let's work on rehabilitation processes and healing processes, recovery processes, so that the violations can end. And so I think we have to, it's an educational process to the public to say, where does our satisfaction lie when the harm stops or when someone gets a long criminal legal sentence, and what happens when they eventually get out, if they get out. And so this is the challenge that we have in thinking about this amnesty and proportionality and conditionality. But I think accountability gives us a container to hold the conditionality.
Muchas gracias, Professor Stoffer.
Thank you very much, Professor Stoffer. I think that Amir wanted to mention something.
Yeah, indeed. Thank you. Just to follow up on that as well, I think maybe the answer also lies, I mean, the question was, what are sort of examples of limitations of freedom? The answer may be in talk to the victims in that particular case. Look at that particular file or the particular accused. What is it that he's done? Ask for submissions from, amicus curiae, from NGOs. Maybe you can hear them. Ask for submissions of victims. We had one case that came to my mind as well. Also, this lady, she testified and she returned to Bosnia, in a small town. And a couple of years later, the person she testified against moved into her building. So the former war criminal basically was released, moved into her building. So that's clearly something that you want to prevent, and this causes a lot of stress and re-traumatization. So, so if somebody's telling you, if this person comes back to my community and I have to see them every day, maybe there's a way to avoid that. I don't know. I mean, so just listen, I would say listen, and I think that follows up with what Carlos was saying.
Gracias. La doctora Naomi también quiere participar.
Thank you. Dr. Naomi also wanted to give a comment to these responses. Yes, just briefly. I just wanted to say that I believe that the way in which reintegration or rehabilitation of the perpetrators takes place is different from location to location. There are places where everybody's a survivor, and there are other places where they aren't. There are places where there are local organizations that are strong and can work on this encounter process, and also independent from the state, such as the program that we heard about from Sierra Leone, where the state wasn't actually present. And sometimes when there is a social organization, a strong local and social organization, that could be much more effective. And in other places, the social tissue is completely fragmented, and what they need is some sort of encouragement or stimuli to try to rebuild it. So to me, it's not a matter of yes or no. It's not about doing it or not. It's about an analysis from the territory's perspective, from the specific territories, from the social composition, that is going to give us an idea about how to face these series of challenges at the local level and at the national level. Thank you very much. We only have time left for one question, so I will try to do something. So I'm going to merge all the questions submitted by my colleagues, because I feel that they are very much connected. One of the magistrates is asking if the transitional justice judges should apply restorative practices, or is it possible to delegate this to an expert, considering that there's already a scenario of how restorative justice is built, but if these transitional justice judges should apply them in the hearings or not, or if on the contrary, they should be restorative practices that go in parallel or that are incidental within the proceeding. And this is also connected to another question, which is how can we create compatibility of being a transitional justice that applies restorative justice with the fact that we're also a court? And of course, this implies a series of procedures that go hand in hand with ordinary justice, but also with international justice. So we have resources, appeals, or allegations. And what would be the procedural structure of justice? And how can we create compatibility in doing restorative justice with the fact that we are court, and therefore we have all these types of procedures? And at the end, we want to arrive at a sanction that is related to restorative justice. And it seems to be complicated that ordinary justice procedures can actually get to that outcome. So those were the two questions that I wanted to ask you. And I don't know if any of you would like to start by giving an answer. I know that they're very complicated questions. I could start with a couple of ideas, and then my colleagues and Naomi can probably add to this. In relation to the first question about applying restorative practices, if you're the judge or not, I think that we mentioned how important training and preparation is to be able to address the restorative perspective, because it requires a change in mindset as well for a judge, a legal judge in criminal law, for example. And maybe it's not that easy or that evident to adopt these changes. So instead of applying it yes or not, or whether to delegate it or not, I think that the judge needs to understand and needs to be well informed. I think that there are satisfactory experiences in the sense they need to be trained to understand all the objectives and the possibilities offered by a restorative justice perspective. And of course, he needs to rely on other experts and other organizations for the specific enforcement of measures. But I think that the judge should not be completely disconnected from this. I think that they should be trained and understand and work in connection with other judges that could provide them support. And in relation to the second question, there's a bureaucratic system that has to be respected that sustains due process. And therefore, we need to be strict and rigorous in the compliance with all those steps and processes. So, of course, we also have virtue in the middle of all of this. And I think that you're doing it as well. I think that finding that new focus on the role of victims throughout the process is already an approach to restorative justice. And I think that we need to ask ourselves a question as a court about what can I do to make sure that all these steps in the criminal process have a reparation effect on the victim so that they don't feel used and that they're only informed at the beginning and at the end, but the court as a system and in coordination with national and international entities to make sure that all steps serve to repair the victim. Whether or not they get to the end, the idea is that they consider that they are well informed. And there are some cases. We have cases of judges who have sat down for hours listening to the victims and explaining the proceedings to them. I think that that cannot be lost in this turmoil and the universe of judicial democracy or bureaucracy, which is very important. And finally, I think that you're also implementing psychosocial support processes and support for victims, which doesn't necessarily just have to be in the hearing or in the preparation of the hearing, but also to navigate all the technical complications involved. Thank you very much. Professor Stauffer, you raised your hand.
Yeah, I just wanted to add briefly to those questions. I think one of the beautiful things about the Colombian situation, as unique as it is that it is trying to say we want to work in collaboration. It wants to be a cohesive system. And so I think that is both challenging, but very important that we work at. So I'm concerned that if we separated those two aspects, that there would be a number of issues involved. One is the capacity. If you give it to the NGO or the civil society, is the capacity there to carry that out? Are there professionals in that civil society that can carry that? And how will it be well integrated? How will there be good communication and connection between the legal process and that? I would be concerned about capacity. The second would be, would it lose some of its power? Because part of the legal mandate of this is what makes it powerful in this process. And if it becomes an add-on to a legal process, it could lose its substance. And so I think those are two things to think about carefully in sort of this delegation process, even though I understand that feels more comfortable probably. I think the other thing to add to what was said before about virtue and of course the whole legal precedence is very important and we're bound by those things in many ways. I want to emphasize the discretion of the judges, the legal discretion that they do have, and how can they think creatively within that doesn't break precedents or break their legal mandate, but that discretion is called forth even more in this case.
Gracias. Naomi también tiene la mano levantada.
Thank you. Naomi also raised her hand. Yes, I just wanted to add to this. I believe that we are all pretty much going on the same path, but what I would be concerned about is that a victim would arrive at the hearing and that they leave the hearing without having a clear idea of what is going to happen afterwards and what this hearing was for. And that is the great concern that I would have in trying to separate this. I agree that there's a need for training and there's a need of multidisciplinary teams as well. This means that the judge doesn't need to be an expert in everything, but they can use the knowledge and the expertise of others as inputs to a process that is tightly connected to the legal process so that the victim can see that progress is being made. That is the great concern that I would have in separating both things. And also, many things happen from one moment to the other that could actually derail what is happening or discredit it. I see it actually dangerous in separating these two roles too much. In relation to the procedures, I think that we need to have guiding principles in the sense. The principle of due process, or the principle on focusing on victims, or the principle of using precedents and established rules, but in a way that also show the power of the judge in innovating within the process. It's not that everything is already structured or designed. There are things that happen that they didn't thought of so many years ago when they thought about the structuring of HEP. So we need to allow judges within these guiding principles to also innovate based on what he or she is hearing from the victims and even what he or she is hearing from the perpetrators. Where this proceeding, of course, in respect of these guiding principles once again, and to lead to where the parties want to go to. I think that that would be my contribution to this question. Thank you. Thank you very much. Well, finally, to close this panel, we have a question that has been submitted many times. And I would like you to sum it up in one single phrase, because this is a present concern when we are thinking about these remedies, sanctions, and reparations, which is, I think that you all mentioned this in your presentations, but we would like to conclude with this, which is how can we achieve these sanctions, remedies, reparations in a process where we do not re-victimize victims so that we effectively achieve this participation? What would be the main idea that you would want us to understand, not just in the special jurisdiction for peace, but also for all the people who are working in restorative justice or who are in transitional justice processes? Naomi, would you like to start perhaps? Just because I have you on my screen. Well, yes, I believe that there are several things that could help. And there are some dilemmas being created here that we need to consider. The obvious thing, of course, would be the support so that victims are not left alone, that they have psychosocial support and it's not just limited to the hearings, and that they receive clear explanations of what is going to happen, what is being done, and that they have access even when they return to their villages, which is where we always see failures. When they're in Bogota, everything seems great. There's support, there's everything, but then they go back to their villages and all the support disappears and they are left with nothing. So we need to think about this type of support that we offer them and to extend it longer over time. That's one thing. And the second thing is that there's a dilemma, the dilemma of how much evidence is needed to establish certain things. We need to present a death certificate of these people, or we need to submit a marriage certificate, or they need to present this and that, right? And Is that necessary to prevent fraud? Yes, it is, but it's also a source of re-victimization. And the way in which I have thought about this, we have actually discussed this with many other colleagues. I've thought that it would be good to have some sort of point of contact for victims and to help them with all these processes, because these are tedious processes and sometimes they face a state structure that is not so empathetic. So having some sort of intermediary that could help them with these types of processes, I think that it would prevent re-victimization. And the third thing, which I believe you're doing, is to not make victims to tell the same story over and over again. They can tell it once in a way that it meets due process and that it's recorded and that's it. There's no need with the technology available to make people do the same thing over and over again. And that could be very re-victimizing. That would be my answer.
Fernando, sigues en mi...
Thank you very much. Now, Fernando, you are next one in line. Well, I very quickly want to say I agree on this point of accompaniment, and I believe that an accompaniment is needed beyond those instances of the judicial process, and to design these interdisciplinary processes that accompany victims. However, I believe that it's something that is needed in the most perfect accompaniment process that I want to highlight at the end, which is the sensitivity of that official, that legal official in general. Sensitivity needs to be there. And for this sensitivity to be maintained and to be empathetic with the victim, one must also take care of the judicial or legal advisor or official, because this person can suffer from burnout due to the workload, due to the burden of the work they do. So I do believe that victimization, in my experience working many years with victims, is due to mistreatment, for example, when they engage with the institutions. And many times at the other side, we see an official that is mentally exhausted from all the work. So I think that sensitivity is perhaps a very, it's a much more of a human concept rather than professional. And to be able to maintain it, we need to align it with management and process designs to maintain sensitivity and empathy of officials. This is very important. Hamid has also asked for the floor.
I don't know how to.
We would now go to Amir first.
Sorry, I don't know how to digitally raise my hand, but very interesting questions. And I just turning back to the previous question, I definitely recognize some slight discomfort that maybe some judges may feel in sort of getting this additional role to find how to implement transitional justice and restorative justice in these roles. But I will tell you, maybe don't be afraid. Now, I don't have that answer for you, but I've seen definitely when the ICC came here and some colleagues who moved there or to these other courts that suddenly had victims participating in the courtroom, all the people working for the ICC where we didn't have that, they were really scared and sort of like, how do we deal with this? The trials are already so long. How do we find a place for them? And the defense counsel complained, well, now we have 2 prosecutors against us. It's 2 against 1. That's not fair. But everybody's sort of finding their role and place in here. And as has been mentioned, you have a very important broad role, and take it as something. Don't be afraid of it. Take it as something amazing, and you actually have a chance to evolve this system. Look at what the ICC has done. Not a lot of things there didn't go always as planned, maybe. A lot of inconsistencies, perhaps. Look at what other courts have done. The Kosovo court is also doing something. See how they talk to them. See what they're doing. That might give you ideas. On the last question, and I'll try and be very practical and brief. Very important question, re-traumatization. But also remember that for some victims, it's a huge relief. It's to come and testify. It actually works positively for them. It is individual. I've seen it both sides. Outreach, hugely important. ICTY could have done better there. Not necessarily judges, but public professionals, public relations professionals, others, victims, talk to communities, universities, schools, include this in school classes. And as Naomi has mentioned as well, they don't need to come and tell these stories all the time. And yes, maybe sometimes they need to be cross-examined because that's the right of the accused. We have to respect it. But at the ICTY, we at one point we did not more to shorten proceedings. We admitted written statements, and then if there was anything going to the acts and conduct of the accused himself, then you testify only for that live. You don't need to retell the story of how your close loved one was killed or horrible things. So written evidence, the psychologist support has been mentioned already. Don't need to go into that. There's professionals who can support judges with that and prepare the witnesses. Adjudicated facts may be another thing. In Rwanda, the ICTR, at one point they said, okay, we've established genocide happened. We don't need to establish this all the time. At the ICTR, again, armed conflict, okay, it happened. You know, certain crimes, you can say they happened. Crime base is not difficult. Nobody should really challenge the fact that many people were killed there, you know, false positive. This is established. You don't need to do that. I mean, let's just look at what did the accused do here, and maybe that's the focus, should be the focus. Okay, enough. Thank you so much.
Muchas gracias. Y finalmente, Carl.
All right, thank you very much. And finally, Carl, you have your hand raised, so please take the floor.
Thank you. And I will just agree with quite a few things that have already been said, but I'll try to do it quickly. I do think this idea, as I said before, trauma, recovery, and resilience is a baseline that we have yet to find out really important ways of doing collectively. I give an example when working with the affected populations in the refugee camps after the Sierra Leone war, 800,000 refugees. There was only 2 trained psychologists in the whole country of 4.1 million people. So we can't rely on the therapeutic model at this point. We have to begin to think about collective models of recovery and resilience, and those approaches are emerging, and that's great. Second, on truth-telling, you know, I'm concerned that sometimes the truth-telling process is overemphasized to the point where it is become synonymous with healing. A truth does not heal. It can be used also to harm and to re-traumatize. And so I think we need to understand truth is really important, but healing is separate from that truth. I think of the South African preamble to the TRC. It says we need forensic truth. There's personal truth. There's political truth, but there's also healing truth. We need to find that healing truth. What is that? It's a compromise, maybe a combination of all of those. On reparations, I'm concerned that we continue to move our eyes not only on monetary reparations, but very symbolic reparations. I think it's really important. Many times it's because we have only done the monetary, which seems cheap and too undignifying for those who have lost loved ones. And so you find in South Africa, for instance, because there was a once-off monetary payment, you have class action suit of thousands of victims now lodged in New York City to try to get money from the major corporations of the United States who stayed invested in South Africa and never moved out. So this thing of symbolic and other ceremonial ritual meaning is really important. And that applies to 2 other practical things: storytelling and arts-based approaches. We have to concentrate on memorialization. How do we remember rightly in a violent world? How do we remember without revenge? And I think that sometimes our memorialization also helps to put up the bifurcation of the conflict when we memorialize in separate groups. So how can we find unifying memorialization processes? And lastly, I think it's important not only to hear the victim's voice once at the beginning or in a certain hearing, but to find the platforms for interlocking spheres of dialogue to continue throughout the process and in the society writ large, so that it's not an unusual thing for the victims to be able to have their voice amplified regularly. How we tell that story is really important also. And so I think we need to continue to think about our communications and media strategies in telling the story in such a way that it educates and points towards interdependence and healing.
Muchísimas gracias. Bueno,
Thank you very, very much. And with this, we will close. I know that my job as a moderator would perhaps be to achieve a summary of this very interesting panel. However, I believe that you've provided such good ideas, great examples of the good, the bad, and you've also left us with a really important reflection for work that it would be impossible to collect it all and not be able to pass this minute that I have left. So I just wanted to close and thank before we leave. I want to thank the 4 panelists. Your work definitely enriches ours, and the fact that you've taken the effort to be here with us for 2 hours sharing, well, this is very, very valuable for the Special Jurisdiction for Peace. So thank you very much for participating. Thank you. Thank you also, Magistrate Margarita Alexandra Sandoval, because aside from the presentation of your ideas, you have also taken the time to respond to the questions from all our participants. We've had 3 acknowledgement and responsibility audiences for war crimes and also humanitarian crime from the public forces and the FARC in the Special Jurisdiction for Peace in Colombia. Yesterday, we presented the documentary Kidnapping is Damaging Love that recorded key moments of case number 001 of kidnapping. This documentary was made by Isabel Valdez, and it is part of the first series of documentary work on restorative justice that is called No More Silence, that will be launched this next Sunday, October 30th, of all platforms of the Jurisdiction for Peace. And now we will present the second episode that corresponds to key moments of the audience of acknowledgement of the case 003, known as False Positives. This documentary work was made by Micol Acuña, and it's called We the Crazy Were Telling the Truth.
Mi nombre es Blanca Nubia Monroy, madre de Julián Oviedo Monroy, joven desaparecido 2 de marzo, asesinado el 3 de marzo del 2008. Julián era un muchacho humilde, un muchacho común y corriente, lleno de sueños. El día que se fue de la casa se fue feliz, porque iba a conseguir plata para pagarle la casa a su cucha, para que no nos sacaran de la casa. Pero lo que él no sabía era que iba a un encuentro con la muerte.
Buenas tardes, pueden tomar asiento.
Estos seres queridos que ustedes me levantaron.
Ni eran ni tuvieron que ver nada con la subversión.
Nadie sabe el dolor de una madre cuando pierde un hijo. Es un vacío que nunca se quiere.
La experiencia que yo he tenido de la justicia ordinaria a la justicia de la JEP ha sido muy distinta, porque nosotros llegamos a la justicia ordinaria y a nosotros nos trataban como si fuéramos lo peor que había en el mundo. Nos tocaba quedarnos calladas de todo y escuchar todo lo que estaban diciendo de nuestros hijos, que eran unos guerrilleros, que eran unos subversivos. A Julián lo acusaban de ser integrante del ELN. Julián se va el 2 de marzo, el 3 de marzo lo asesinan. ¿En qué momento Julián se convierte en un subversivo? Pero sí, fue muy distinta la justicia ordinaria a la justicia de la gente.
Evidentemente ha habido cambio porque frente a la justicia ordinaria siempre se sostuvo una mentira. Llevamos más de 14 años con unas víctimas que estaban desde hace 14 años clamando la verdad. Y vemos que la Jurisdicción Especial para la Paz ofrece esa posibilidad de que nosotros los victimarios, de alguna manera, frente a una deuda que teníamos con estas personas, tratemos de sanarlas ofreciéndole la verdad. Debo reconocer que estas personas que fueron asesinadas eran ciudadanos, campesinos, trabajadores, padres, hermanos, hijos, esposos, y que sus conductas eran intachables, buenos seres humanos, y no eran, como se dijo, integrantes de grupos al margen de la ley. Esto se manifestó al comienzo de esta farsa, de esta gran mentira que sostuvimos por 14 años y que hoy, gracias al Sistema para la Paz, podemos restaurar esa dignidad humana de cada una de las víctimas.
Entonces, cuando usted dice que usted reconoce su responsabilidad como coautor, ¿qué reconoce? ¿Haber hecho qué?
Haber dado la orden de haber asesinado personas.
Por un lado me siento tranquila, pero por otro lado sí me da tristeza de oír de que estas personas están diciendo de que mataron personas inocentes y que ellos sabían de que eran personas inocentes y no les tembló la mano.
Doña Blanca, desde el primer inicio de estos procesos, cuando estábamos en la jurisdicción ordinaria y teníamos que ir permanentemente a estas audiencias, viví de cerca el sufrimiento en todo ese recorrido jurídico, y que por tantos años ella asistía de manera solitaria a esas audiencias, donde en muchas ocasiones y después de un recorrido desde Soacha hasta esos juzgados especializados en Cundinamarca, llegaba y se suspendían las audiencias. Y no fue una vez, sino muchísimas veces. Y ella, pues, como lo han dicho todos, clamaban justicia, pero la justicia no llegaba. En esas audiencias mostraban las fotos de su hijo asesinado de una manera que considero que de alguna manera revictimizaba a doña Blanquita. Y ella en la parte de atrás de la sala, pues, lloraba al ver estas fotos. Y en esos momentos me sentía el ser humano más miserable y despreciable por lo que estaba pasando con esta señora. Y quiero decirles a todos ustedes que doña Blanquita, y le quiero decir a usted, es el ejemplo de lo que representa el amor de una madre.
Siempre la verdad sale a relucir. Y esta vez la verdad, la lucha que nosotros hemos tenido no ha sido en vano. Ya al menos vemos unos generales acá sentados y eso era lo que nosotros queríamos saber. De que Colombia supiera de que los jóvenes de Soacha y los jóvenes del resto del país que fueron asesinados por estos militares no eran guerrilleros, eran niños, eran campesinos, dejaron familias, dejaron hijos y nos dejaron un corazón vacío, unos brazos desocupados. Se dan cuenta que no, las locas no estábamos siendo locas, estábamos diciendo una verdad. Nuestros hijos no eran guerrilleros, nuestros hijos eran unos muchachos de bien, humildes, trabajadores, pero eran unas personas de bien. Incluso hace poco me encontré con el señor Tamayo. Le dije yo, si usted sabía que Julián era inocente, ¿usted por qué no le dijo a la señora juez de que mi hijo era inocente? Él me contestó y me dijo, no, me pudo más el ego que yo tenía, porque en ese momento yo tenía mucho ego.
Es difícil, supremamente difícil pararse usted frente a las víctimas a asumir la responsabilidad de a contar lo que pasó. Asumir esa responsabilidad, en el caso mío como comandante de un batallón donde habían más de 850 hombres. Muchos de los casos sabíamos a plenitud qué era lo que estaba pasando y otros sin sabernos y no se hizo nada para haber evitado que sucediera lo que pasó. Durante estos 14 años estuve 8 años privado de la libertad. Siempre llevé en mi conciencia ese cargo de esta responsabilidad. Ahora con esta audiencia de responsabilidad, esta audiencia pública y los ejercicios que se han venido realizando, he descargado también y he empezado un camino de sanación.
Esta es la paloma de la paz. Estos dibujitos, aquí está mi esposo, aquí estoy yo, estamos cuidando estos otros 3 hijos que nos quedaron. La tela roja es la tela que yo hice de donde están todos los 19 militares que están implicados en la muerte de mi hijo. Hice la carretera que mi hijo caminó todo el tiempo, y cuando llega allí están los militares que me lo asesinan. Y le doy gracias por usted estar acá. Siempre me imaginé, siempre soñé de que iba a llegar ese tiempo donde ustedes me iban a pedir perdón por la muerte de mi hijo y donde ustedes iban a decir de que Julián no era ningún subversivo. Hoy lo viví, hoy Dios me dio esa alegría, y bueno, pues, y yo les digo a ustedes lo que les dije esta mañana: no se dejen echar el agua sucia, que hay otros implicados. Voy a seguir luchando para que la JEP llame a estas personas y yo saber la verdad, yo saber qué fue lo que pasó y ellos qué fue lo que le hicieron a mi hijo.
No más silencio.
No More Silence. That's the first documentary series on restorative justice in Colombia that will be available in all platforms of the HIP as of Sunday, October 30th. Now we'll give floor to the panel with academics, judges, and victims. This session is fully dedicated to listening to the opinions and/or responses that the panelists may give regarding some questions related to the topic that brings us together. For example, how can transitional justice contribute to strengthen the sustainability of transitions that are key in the strengthening of rule of law, accountability, dignification of victims, and reconciliation? What are the practices of transitional justice or past treatment that we could learn and deeper interact with? What are elements of current transitional justice to be able to comply with objectives such as minimizing the suffering of victims, social reconciliation, as well as the strengthening of rule of law? How can we manage the attention when applying restorative justice in transitional contexts when the armed conflict is still happening? As guests, we have, and we want to thank you for your presence, Gabriel Pereira, researcher at the National Council for Scientific and Technical Research of Argentina, co-founder and president of the human rights organization Andes by its acronym in Spanish, of which he was joint director and director. Mariana Cacique Peña, advisor in the areas of transitional justice and victims' rights and coordinator of the Law and Peace Practice Group of the Institute for Integrated Transitions. She worked as a consultant for the Presidential Council for Human Rights in Colombia and as a legal advisor to the Victims Unit during the negotiations between the government of Colombia and FARC, as well as during the subsequent implementation phase. Andrónicos Urbay y Puana, indigenous judge of Colombia, member of the Autonomous Major Board Organization of Puchipu. Jairo Ignacio Acosta Aristizabal, attorney delegate with intervention coordination functions for the Special Jurisdiction for Peace of the Attorney General's Office. His career includes positions such as delegate judicial attorney before the Superior Court of Bogota and before the Court of Justice and Peace. Inside this branch, he has been an auxiliary magistrate of the Superior Council of the Judiciary, a criminal judge of the Specialized Circuit of Bogota, and a specialist prosecutor. We also have Daniela Arandia with us, accredited victim in the macro case number 1 of the TEP, taking of hostages, serious deprivation of liberty, and other current concurring crimes committed by the FARC-EP, daughter of Geraldo Arandia, kidnapped and disappeared geologist, and Marta Espino, business administrator and tireless searcher. We also have with us Jacqueline Castillo, accredited victim of macro case 03 of the HEP killings and forced disappearances presented as combat casualties by state agents. Case false positives. Jacqueline is the sister of Jaime Castillo, a Bogota trader who disappeared in Bogota August 2008 and was reported by the authorities as a guerrilla killed in combat in Norte de Santander. To all of them, thank you very much, and the moderation will be in charge of Ana Manuela Ochoa Arias, Magistrate of the First Instance Section in cases of recognition of truth and responsibility of the HEP. Thank you, Magistrate. All right, good morning, and thank you very much, Clara, for this introduction. Please, from all the organizing team of the Second International Conference, a very special greeting, and thank you all for participating and for your interest in the Second International Conference.
A este panel con víctimas. Este es un panel muy diverso.
I want to welcome you to this victims panel. This is a diverse panel because we have the participation of accredited victims as well as judges and academicians. I want to thank our panelists who honor us with their presence in this space of learning. On behalf of the jurisdiction, I want to thank you for your participation, for your time, and for your knowledge that you are going to share with us. Madam Clara already read the questions that we're going to address in this panel. And as you saw in our program, this session will be focused on listening to the questions, to these answers. So I am not going to repeat the questions, but I wanted to tell you what are the rules of the game. I think that you have probably been here since early this morning. You know that you have 15 minutes to give your remarks, and in that time, you can actually answer the 4 questions read out by Clara. And if you prefer, you can also emphasize on any of the questions raised. You already know that there's a stopwatch that will tell you how much time you have left for your remarks. And I wanted to tell you the order of your interventions. We are going to start the panel with Ms. Daniela Arandia. Next, Madam Jacqueline Castillo. And then we will give the floor to Indigenous Judge Apu Chipu. And we will give the floor to Mr. Jairo Acosta. And afterwards, Mr. Gabriel Pereira and Madam Mariana Casic Peña will close our panel. So we hope that once you complete your presentations, we hope that you can stay on time. We will then continue with the Q&A session. As we saw, it is a very enriching session for all of us. So with no further ado, we want to thank you once again for being here. I want to start giving the floor to Daniela Arandia. Please go ahead. Thank you. Can you see me? I cannot see my camera, I'm sorry. Yes, we can see you and we hear you perfectly. It should be an internal issue here, don't worry. Well, thank you very much. First of all, for inviting me to the session. I read the questions and now internalizing this situation, I realized that there was a general issue that raised my concern about the 4 questions raised that are aligned with the previous panel. They are connected to the topic of discussion in the previous panel, and it's also important to me. Unfortunately, in Colombia, and based on what I've heard from around the world, when a re-victimization situation happens, then re-victimization or re-traumatization is a common issue. And this is a matter that unfortunately is also created from these government or non-government entities that are supposed to help victims. So over time, over the course of these 22 years, since the kidnapping of my father, the different doors that we have knocked on, and mainly with the work done by my mother, we haven't been treated appropriately. And the state and the government has become a secondary re-victimization stakeholder in many cases, too many of them. So the fact that, unfortunately, people who work in these positions and in these roles that have had to help us haven't had gone through true training or education, because this is also related to education, and the need for emotional intelligence of humanizing this issue and to establish empathy with people and with the situations that are existing in the country. Therefore, this has led to strong barriers, not just for victims or the family members of the victims, but also for the people whose main victimizing entity, or in this case, FARC, to create this discomfort, but also in the type of support or the psychosocial support or the therapies. This is where we see this type of situation arising, because they do not understand how to treat victims or perpetrators. And I have been working on my mental health lately. I never wanted to address this issue as a victim, because when I had the psychosocial support from the entities that were able to help me with a psychologist or something similar, the main topic was always my father's kidnapping. And all of us who have gone through a similar type of situation, we aren't just victims or the families of the victims, but we have our own lives. We need to live. We need to go through daily activities that don't necessarily need to be focused on the situation as such, but they want to leave us there. They want to simplify the life of a person on a single situation that probably has a great influence on everything that is happening to us, but they want to just focus on that single situation. And that creates huge barriers in relation to the process. Because one of the things that it's important to me that is happening right now with HEB, in this transitional justice, we are not talking about punishments. We talk about imprisonment or these types of topics that people don't really understand. Most people who haven't had to go through these types of situations, this is what I've seen. So we need to humanize this process. This is what we have seen with the hearings, with the encounters that we had with the perpetrators. We need to humanize the process. We need to create sensitivity towards them, because we are used to seeing everything flat in ordinary justice. And since it's that flat, it takes us back to this re-victimization that we talked about before, because they don't understand. They haven't gone through a process to truly understand the suffering of others. And we shouldn't just talk about pain as victims, but also as perpetrators, because there's another issue here. And I'm sorry, I'm mixing all ideas together to take advantage of my time. But this barrier that is created between victims and perpetrators is also affecting us a great deal in the process, and it has affected us for many years. Of course, and I am aware of this, that this couldn't have happened overnight, because we all need to go through a process, individual or collective, to be able to understand what has been happening. And we need to have that. We need to have that understanding of the victims and the perpetrators, and understand what is happening and what is happening internally in them. What is the moment in which that person, what is the moment that that person is in? Maybe if these encounters would have taken place probably 2 years ago, at the time where for them it was just war crimes, as just saying that we were at war, then maybe for the victims it would have been too complicated to be in a single conversation with them. So we needed to go through a process. But these encounters, and to create this proximity, allows us to understand that we have things in common. And this has allowed us to understand others better. The fact that Milton de Jesus and his representative, Ana Maria Troncel, have had the opportunity of listening to my mom and to me to tell the story, and to truly understand which were the facts and the factors and the evidence that we had, to know that the first versions about my father's situation were completely erroneous. And then they could understand, okay, now I understand what they meant. For us, this has been extremely important, to establish a bond where it isn't just about, for example, if there's a commitment now, but also that it goes beyond what we have at head, because it's something more personal. And even though this could be a very painful situation for both parties, because it's not just for me to understand what the truth can cause, because we don't know at the end if we're really prepared to hear the truth. But for them, it's also about understanding how their life wasn't on the right path. So it is very complicated. But these lessons learned, what we are experiencing in the hearings and in these encounters, I think that we could not disregard them. And we know that we need this to continue happening, not just with the highest ranking authorities, but also the lower and middle ranking authorities. And I know that I was very fortunate to have had this meeting with Milton, but the institutions and the government need to pay attention to these types of things, and to understand that all of us immersed in the process deserve these spaces. We need these spaces. And of course, in the healing and forgiveness processes and to feel this restorative process. I know that they're completely individual because the proceedings and the facts are completely different. They're a separate world, but we need to have this possibility. There are many people that I've heard from, and I have felt the changes that have happened with them just with these encounters, so that we can see each other in a more transparent manner and to understand each other as human beings that have emotions, that feel pain. We were in some hearings and there were people who were feeling a great deal of pain and they were saying horrible things. And then I wondered, I don't know how the perpetrators are bearing this, but I thank them for being there, that they're also facing this, and that we are capable to also think about this and to put ourselves in their shoes. And I believe that we need to be open minded for the things that, as victims, we are telling them that we need. We need to be truly heard. And that is not just for HEP, so to say, but it goes to the higher authorities. You also need to offer the possibility for HEP to allow us to have these spaces so that we are not limited. It is extremely necessary, and it has been more than 50 years of war that we have already experienced. And I think that to give ourselves the possibility of a space, a place to be able to establish dialogue for one day or two, I think that that is too little. It's too limited for everything that we have suffered as a society.
Perhaps providing a bit of a more global perspective, because I do believe that this work, this more personal work, should be carried out, and also a collective work within the different institutions to be able to help understand the other. And we need to start working on it from the basis in our society, from schools. We need to start to work on mental health. And as I just previously mentioned, it's not only the psychosocial accompaniment that we need as victims or perpetrators, it's also that all the people that have to do in these spaces or must engage in these spaces must have accompaniment. If it's overwhelming for us, perhaps a person that has to do this on a daily basis and also needs that support. So I believe it's the full understanding that as a society, we need to just pay much more attention to mental health, to really be able to empathize with others. And that we need to foster this from our homes, with our family members, from all the people that surround us. I believe that the HIP right now is undergoing this process. It is under development. I don't feel that it is something set in stone. And I do believe that with amongst us all, we can build something to reach that objective that can feel satisfactory for all those people that are part of the process right now. So I'd like to tell you all in general, please listen to us. Take the time to pay attention to what we also are telling you that we deem should be improved. Thank you very much. Thank you, Daniela. Your presentation has been absolutely important, your intervention. I wouldn't even dare to highlight elements from your intervention because I believe that all you said is very important. However, I'd like to emphasize some elements, for example, elements related to restorative justice, on the importance that we need to humanize not only this special jurisdiction for peace and its officials, but also humanize ourselves as a society. I believe that that is of utmost importance, the importance of not re-victimizing do not have to undergo these processes that, as the previous panel mentioned, that you've had to live. So I also believe it's very important, this mention you make, which is also an important element of the restorative justice, which is the need that perpetrators can commit with the harm that they've created. I think that there are many important and vast elements in your intervention, so thank you. And we hope to have the opportunity to continue engaging with you. And with this, I'll give the floor now to Ms. Jacqueline Castillo. Please take the floor. Good morning, everyone. Thank you very much for this very important invitation for us. I have to start my intervention with something very specific. For us, it was quite negative to learn that those who are supposedly taking care of the lives of civilians were actually the ones who took the lives of thousands of civilians here in Colombia. With the question of how can justice contribute to the strengthening of the state, accountability, and reconciliation, I must say that the work that we've been doing since 14 years ago, seeking justice, seeking truth, seeking non-repetition guarantees, as it has just been mentioned a moment ago, the ordinary justice systems is a place where we are just re-victimized. The hearings were actually postponed. There was actually no charges pressed in several cases. This special jurisdiction for peace was created. We opposed that our cases would reach a special jurisdiction for peace because we know that these were not war crimes, these are state crimes, and that is how they should be called, as state crimes. However, we slowly realized of how important it was to learn the truth, of understanding what had happened with our family members and why this has happened. But what's most important actually for us is to really be able to learn who gave the order to commit all these crimes. We have a full certainty that this didn't come from low-ranked military officials. This came from the high commanders. We know now that there has been an acknowledgement from different generals and colonels, but 11 military individuals or members or former members is not sufficient. We know that the Special Jurisdiction for Peace will continue working for territories, and we hope that at one given moment we can really learn who really gave the order of committing all these crimes. We oppose to the fact that you continue accepting omission cases. They had full knowledge of what the army was doing. So nor Álvaro Uribe Vélez, nor the former Ministry of Defense, Juan Manuel Santos, nor the High Commander of the Armed Forces, Mario Montoya, they can't say that they didn't know what the army was doing, because they did know. Several of the appearing parties have said that there was pressure to achieve these results. And I think that this is one of the tasks, so that the Special Jurisdiction for Peace continues contributing to the strengthening that we need to contribute to clarify all these facts. I must confess that through the social component, we never really were able to work with the victims on this aspect, because it was very difficult to, again, tell our stories. We really didn't see a progress in healing. However, I'd like to say that today, 14 years afterwards, we can say how we can work in healing through art and art-based approaches. At the beginning, you saw some of the mothers of these false positives and how they've worked through their memory, through textile design, through paintings. We actually planted ourselves in earth. Some mothers actually tattooed the faces, their portraits of their dear sons. We've also participated in art interventions with murals and more public works. And all this work, joined with the work done in the Truth Commission, is what we achieved to do what we dreamt of achieving, which is have them face to face. And as Daniela just mentioned a bit ago, it's amazing to be able to be face to face with the other, to be able to listen from perpetrators, from their mouth, saying, yes, I literally made a mistake. I committed these crimes. I killed your family, but I am here to see how we can repair the damage that was done. She also said it. Well, time has been very short, and if we had done all this throughout the process, what we've done from 1 year ago, 2 years ago, perhaps we could have had better results. But at the beginning, the hearings were done through a mirror room. We couldn't see them, although in the ordinary justice we always had them face to face. And now, in the work that has now been done with the Truth Commission, to be able to be in one soul space with these space, to be able to have shared a lunchtime, to be able to have handshake, to be able to perhaps empathize and think about what was the other's position and understand why all these horrible events happened, events that should have never occurred, and also learn that they also destroy their families. But we also know that there's still a lot of truth to be revealed. And I think that is the way that the Special Jurisdiction for Peace can contribute to continue pressuring for truth to be revealed. Several of these opinion parties at the beginning were denying everything and said, all this was done behind my back. I did not contribute. I did not know what was going on. But now in the last versions that were provided, they did acknowledge that they had ordered commit those crimes. So we must continue insisting in learning a full truth, not a partial truth. And I think that's something quite important is to, well, we already know that the communication was issued in terms of reparation from the appearing parties. And something that has caused much pain is that they say, well, the JEP does not have money to repair victims. Perpetrators now say they also don't have money. Well, something that we've been claiming for since a long time ago is who will be accountable for the debt that we have, for example, in the cemeteries. The previous panelists mentioned on reparations and projects. And I think that this is a very important product, a very important topic. And we know that there are 7 points that have been established from the JEP, such as, for example, having an exhibition room in the Memory Museum, which would be dignifying for victims, doing a memorial, and that's something we want to work on, because in Colombia, many people say that this is not real, that this figure of 100,000 documented cases, which for us was very, very gratifying to show that this was a systemic practice, that these were state crimes. This is denied by some people, and it's very important for us to be able to create a memorial where the names of those 6,402 young people are there, that there's this space of memory. But we absolutely oppose that the appearing parties, that they will, for example, provide classes and courses on human rights. They don't have enough dignity to do that. And as long as we're living, we will continue giving these courses in schools, in universities. These events cannot be forgotten. These facts and events must be known throughout time in history, so that in some way this is not repeated, and that our youth, the future generations of our country, must learn in time all this that is now part of the history of our country. Documentaries were also proposed. We've done documentaries. We've visibilized these topics not only at a national level, but also at an international level. I had the opportunity to actually go to The Hague. I was there with victims of Yugoslavia and Bosnia, and we saw the importance of being able to identify the bodies and deliver the bodies to their families. I think that the justice, the special jurisdiction for peace, the state must commit so that we can continue working throughout all the country. There are thousands of non-identified bodies, many cases that are not known with most certainty are cases of extrajudicial executions. And we must continue highlighting this horror that Colombia lives. There are military officials that have contacted me and said, Jacqueline, I want to tell my cases. I'm tired of carrying these ghosts. These are human beings. I think that this process is very important to reconciliate with support the peace that the country so much needs. But what's most important is to seek guarantees of non-repetition. We will continue our fight through art and art-based approaches, as I said in the beginning. I think that this is one of the most dignifying ways for us to heal too, and we will certainly continue until we live, as long as we're living and until we can learn the full truth of all these crimes. Thank you very much. Thank you, Ms. Jacqueline, also for your intervention. I believe that both you and Daniela, you have a common point, which is this point on insisting on re-victimization, and this call that you both make from different places with different actors that had this obligation, for example, to protect us as civilians, were the ones who harmed us. And I think that this is very important. And I think that this also provides certain elements to take into account while continuing our work and taking into account in what follows in the different jurisdictions, in the special jurisdiction for peace, both in the investigations as well as in the trials. And I believe that several other elements are important related to, for example, reparations, sanctions, and overall with the importance of the satisfaction of the rights of victims in this transitional justice related to listening to the truth, to the search of other people whom we don't know where they are, where their bodies are, and what happened to them. And therefore, I believe that these calls that you're making for non-repetition, for the guarantee of non-repetition that you're making are very important. So all of this, we hope that contributes to non-repetition guarantees. And finally, you highlight the importance of taking into account these healing processes, not only from what is sentence or a charge pressed, but instead to be able to articulate these remedies that the special jurisdiction for peace will give in many other processes, such as art, as you've been working on and you mentioned. So thank you very much, Ms. Jacqueline, for your presentation, your intervention. And as we said to Daniela, we hope to have spaces to continue this dialogue. And having said this, now I will give the floor to Andronicus Urbay Ipuana from the organization of Puchipu. Andrónico?
Pushwa, Arihuna Yakan, Saint Maka, Taya Colombia, Semana Atacan, Sumatra Hep, Naka. Muy buenos días para todos.
Good morning, all. Thank you very much for your invitation. And thank you for the presence of the international guests, all members from the HIP, and you especially, Magistrate. Well, the Special Jurisdiction for Peace has certain or very specific or very similar procedures to the normative system. The fact of being able to confess the truth is an element that certainly contributes to make the actor of the event accountable. In our justice, what's most fundamental is truth. And reparation, it's not that you would compensate by bringing back to life that family member that has been killed. With reparation, what we mean is to reestablish the harmony between those that are now alive, because life is so sacred that we cannot tag a price to precious and sacred life. So what we try to do is establish harmony with those that are living so that we can live ordinary life and share public transportation systems, go to the same supermarket, coexist. This is a justice that is very similar in its proceedings because it's a dialogue-based justice, but it has most important elements to the Waju one, which is a pluri-managed. And therefore, for us, spirituality has a very important role, and many legal advisors or officials don't really take into account that part of the justice of Native peoples. Therefore, it's very important to highlight that victims, if one is victim, one can confess to the authority whatever happened, and then the authority should be the entity that responds to perpetrators, not directly the victim. And here I'd like to highlight that it should be taken into account. The following should be taken into account. For example, when there's victims for the case of reparation, in terms of special attention. All victims should have special attention, but when we talk about Native peoples, we need special and differential attention, and we would need to consider what's the action exactly that is being carried out with people. It must be in our own dialect, with the people of the same gender, to not re-victimize. We don't have anything equivalent to psychologists. For example, in our peoples, we have, let's say, some sort of psychosocial with the Outso woman, another authority, which is the spiritual authority.
And this is also a way of guaranteeing due process, as you call it. For us, it's not just due process. Due process is with an institution or with a state and with head, but it has to be an intercultural due process. Due process cannot just be seen from one single perspective because it involves an institution. But in our case, the Wayu people, we do it in an intercultural way. We know how due process works here. And this horrible, bloody night suffered in Colombia more than 5 decades ago that has left so many victims, orphans, widows behind, and injured people behind. This doesn't have a price attached to this. The value attached to this cannot be calculated. But us as Colombians, we need to build pathways that allow us to build a culture of peace, which is a harder culture than the culture of violence. When the peace referendum was implemented and no actually won, this meant that we're prepared for peace and not for war. This means that all state instances have to insist on peace. This has to start with the schools, the academic centers, and we all need to contribute to peace. So these are the lessons that we need to learn from this Colombian disgrace, from situation. The only solution has been to kill others. That's a competition for life. But this should not be the path that this nation should adopt, with so many cultural sources of richness, so much water, so many ecosystems. But it should be the path towards reconciliation. But it has to be a reconciliation that is adjusted to the truth of victims so that victims are satisfied with the truth. It needs to heighten their paradigm of dignity for the victims. And HEP also needs to decide by implementing or enforcing the law on the perpetrators. This is a new court, and therefore there's resistance against it. There are many contradictions, many people in favor, many against it. But we understand that it's hard for these crimes to take these people to prison. This is not going to be satisfactory for us. For us, the Wayu people, imprisonment is the beginning of impunity. For us, we prefer the perpetrators to be free so that they can restore and compensate for the damage caused to the family members of the victim. We have been contributing with some elements that have been useful for all judicial operators. Many times there's resistance against the special jurisdiction for peace because we are used to instrumentalist and punitive operators. And as we can see, prisons are not the most humane centers. Many of them have rated prisons as schools for criminals. And we have seen some unconstitutional aspects in 2015 as well. So I want to invite us all as a member of the Wayu community that we need to establish more dialogue because we are a society focused on dialogue. We know that this is not going to fully satisfy victims, but it could contribute significantly to find reconciliation. In the Wayu people, there is no reconciliation if there is no truth, restoration, and compensation. Nor do we have the word forgiveness in the Wayu culture, but it's implicit in the act of the perpetrators, in the actions of compensation that they offer. That is where forgiveness is implied. So if there's no truth, reparation, and compensation, there won't be any reconciliation. So we have had more than 50 years of violence, and they cannot be solved in 15, 20 years of the duration of HEP. And I think it's going to last less because they've already been in exercise for 5 years already. But we are also hopeful and we are optimistic because we expect that this could actually alleviate the burden carried by the victims. As we saw on the video, the lady was left with an empty heart and with empty arms as well. So this justice needs to continue so that we can truly learn about the truth. And I am hopeful. But looking at the truth reparation system is going to leave us with great lessons learned about how we need to coordinate matters in equality of conditions, as not as two jurisdictions with the same dignity. Because in the ordinary jurisdiction, we have had some sort of struggle with ordinary jurisdiction. We have been coordinating our efforts and we have been turning off fires in different places. But we expect to have coordination in plurality, in truth, in diversity, and in law. Because this is a social state of diversity and a plural rule of law. So we need to honor this because we are all part of this beautiful nation that has been bleeding out and we cannot continue on the same path. I have liked the first intervention of this first panelist when she talked about emotional intelligence. I agree with this, and this has to start with children from primary school all the way to university, but they also need to teach cultural diversity, which is the greatest wealth of our country. Cultural diversity, because we need to learn from each other. If that were to take place, we wouldn't have money or indigenous people. We would all be human beings that need to respect each other, and we need to respect the dignity of all human beings. The Wayu system has provided with great contributions in together with the national judicial branch in showing them how we deal with the administration of justice. First, it would be through dialogue, and secondly, the sanctions are financial sanctions, not punitive sanctions, because imprisonment is not going to rehabilitate anybody, and even less in Colombia because there is no policy to reintegrate imprisoned people. So we have contributed to showing how we can have a more sociocultural and instrumentalist than an instrumentalist justice, because we're mostly interested in the human being who committed that mistake. And by this, we're not saying that we are not forgiving the crime nor the perpetrator, but we're actually creating an apology to the justice system that belongs to the special indigenous jurisdiction that has the same value and the same dignity as other justices in Colombia. The special jurisdiction for peace is interesting because it shows the true paths that we need to follow to be able to partly solve with the truth and solve these more than 50 years of violence with the truth, because there had been other accords with Dr. Virgilio Barco with the M19 for justice and peace that did not show that efficiency or efficacy. Maybe they took it too lightly. And also the issue when the people reinserted started to be abolished. That cannot be that way. We need to have true pardon, true forgiveness based on truth, where this agreement is respected because this is an agreement between the state and FARC. At that time, FARC actually exerted plural and legal system, but now they need to be subject to this same system. We want this jurisdiction to continue with these efforts in conveying the truth so that we can partly repair the victims. As we said in the Wayu justice, we do not offer reparation to dead people. We offer reparation to the people who are alive, because life is so valuable that we cannot assign a price with any object in this world. So life is so sacred that needs to be respected. It needs to be respected, and it has to be respectful of how we are. Just like we are part of this world, we expect that all beings can also be respected in life. And finally, as I said before, dialogue is the instrument that can allow us to agree on peace and to partly satisfy the great injuries caused to this Colombian society and the beautiful cultures in this community. Thank you very much for your invitation, and we are open to any questions. Thank you. Thank you very much, Andrónico. And I also want to thank you for reminding us of the sacred value of life. I just wanted to point out that we had told you that this was going to be a diverse panel, and I believe that the interventions that we've heard are an evidence of this. As you know, in Colombia, we have 115 indigenous justice systems, and each of these indigenous systems represent one type of community. This means that we have 115 indigenous communities. And one of the things that the Special Jurisdiction for Peace has adopted, considering that restorative justice in general is mainly based on indigenous justice systems around the world, especially in some countries in the Nordic region. And one of the things that we have done here in Colombia is to learn from the justice practices from indigenous communities, just like the one that Puchipu Andrónico has mentioned, considering how important it is to understand which remedies they have adopted in some places in Colombia for these types of situations. or violations against the human rights of some of these communities. So it is important. I believe that Mr. Andrónico has taught us great lessons, and I think that they are important in the context that we're discussing here. It's important, his remark regarding imprisonment, because he said that imprisonment is the beginning of impunity according to Wayu communities, and they would rather have people outside free, restoring, instead of being left in prison. So he said that prison centers are not human or humanized places. And he also mentioned the current state of the prison system. He also mentioned the values of the Wayu legal system, which are also in alignment with this transitional system and restorative system, such as truth, reparation, compensation, and reconciliation. I think that these are all important aspects for the work that the Special Jurisdiction for Peace is doing. And I think that all three interventions have mentioned about the importance of listening to each other and having more opportunities to listen to each other within the Special Jurisdiction for Peace. So with this, I want to give the floor to my second guest, Mr. Gabriel Pereira, so that he can continue with his presentation. Professor Gabriel, the floor is yours. Hello, ladies and gentlemen. First of all, I want to thank you for your invitation, and you really do not know what to contribute or what to say because of the information given, not just in these 2 days of the session, but also in the past times in the fight for justice. Truth has shown us many discussions that are underway. I am going to add to the previous interventions because, of course, I am going to give you a different perspective. I will try to give a more macro perspective of some situations that have been happening in Latin America, especially in relation to transitional justice, and with some comparisons, of course, and also highlighting on a more academic perspective, if you may. So I apologize for not being aligned and to mention some complexities and nuances that you have in Colombia. But of course, I am not an expert on the matter, but I wish to continue learning. In relation to the questions raised, I am going to mention some ideas that could be useful. The first question about how transitional justice can contribute to the sustainability of transitions. I believe that there's a lesson in Latin America that has an impact on other of the topics mentioned here, which is the idea of transitional justice as something that has been limited, temporary in time. And if you look at the experience around the region, transitions are actually longer than expected. For example, in Argentina, they have been through 40 years of transition, or that transitional justice is not temporarily tied to this transition. I believe that the experience of Latin America leads us to think that we need to have certain flexibility in this matter of temporality. But this is not a minor issue. And transitional justice, when we believe that it only contributes to transitions, then they fall short. Argentina, for example, Brazil, and Chile continue to have transitional justice mechanisms that started out 4 decades ago. So transitional justice strengthens and consolidates a transition. But if these transitions are short, or we believe that they should be short, then transitional justice will be doing more. And this is a responsibility that in the first moments of anxiety, we cannot act the stakeholders involved. But we need to consider the macro analysis. We could contribute more to a transition if we understand that transitional justice is not tied temporarily to these transitions. They last a bit longer in time. So I believe that in that sense, what do we understand as transitional justice? If transitional justice is a series of recipes, policies that need to be implemented, either because they come from outside of the context where they're being implemented, or because they are agreements reached by that same society, or in relation to the more than 100 indigenous justices that you have in Colombia, or if there are reactions from the society against the atrocities in the past or the violent present that you're experiencing. So if you look at transitional justice as being tied temporarily to these transitions with the temporary perspective of the transitional justice mechanisms, then we have a tendency to think that transitional justice are just a series of recipes and fixed and stable mechanisms. Not stable, but specific. So we will say that transitional justice are memory and truth policies through a truth commission and through a special jurisdiction for peace and for specific mechanisms for reparation, land restitution, and so on. And the issue is that time and societies change, and we need to be prepared to think. And for that, we also need to be flexible to those changes and to think that transitional justice mechanisms cannot be stable or fixed. In Argentina, just to give you an example, we have always had the Truth Commission, the trials, but at some time we had impunity, then we had more trials. And 40 years later, when we already know who had been indicted or appointed to have been participated in crimes against humanity, they are dying now. And now we need to think about different methods of transitional justice more than what had been implemented, because the context forces us to do this. And what do I mean by this? If the process is longer than what we expected and the mechanisms need to be flexible, then maybe those objectives of transitional justice that we have the intention to apply, just as we have seen throughout this conference, these restorative objectives, these dialogue objectives and retributory objectives as part of the reparations, we have financial retributions versus restorative processes, then the balance and the tension of these objectives also change.
Now in Argentina, after having, let's put it somehow, satisfaction of the retributive objective through the criminal justice, if we see 40 years later, with certain analysis or self-evaluation, critical one, of how much we've advanced in the restorative realm. However, at that given moment, it was important to think about the retributive one as most important. The retributive, for example, as a criminal sentence or a sentence beyond what a truth commission can provide. So also from a more macro perspective, to see the transitional justice process is not a temporal one and not necessarily tied to a transition, and also consider the flexibility of mechanisms of transitional justice is also enriched when we see that not only will they be the same tensions, and we can therefore grow, providing priority to some objectives versus others. And I feel that the flexibility of the objectives of transitional justice is certainly a contribution to consolidation. I believe that now the human rights progress that we've been progressing in Latin America and several countries with its laws, of course, but what we've been experimenting in the region, a consolidation of a region that does not have wars, that does not have internal conflicts, where we have a vibrant constitutionalism. That is certainly part of the transitional system, and to see the whole process. And I can't really talk about Colombia. You are entering a transitional justice since you said that the transitional justice system would be implemented. So when we talk about transitional, or rather transitional strengthening, we deserve to have a debate and say that goes beyond just having a contribution to a transition. It is a culture of human rights, and we must rethink our own concepts and temporalities and objectives. There is then another element that is also within the questions, which are these more broad visions. And we can say, okay, what practices? We generally think what mechanisms worked best in certain contexts or at certain moments. And perhaps the experience of Latin America and of other regions might as well also tell us and show us that it's not so much about the mechanisms. For example, the Special Jurisdiction for Peace, the Truth Commission, the land restitution system, but also the conditions, and that we must work so that the conditions of effectivity of those mechanisms can make it possible. And there, I believe that there's a lot, and there are colleagues that are here in this session that have been working on this. So there are conditions that are clearly tell us, all right, well, the objectives of transitional justice, if these are not driven, if these are not mobilized by the civil society in a vibrant manner, for example, communities of victims, family members, and social organizations, well, it's very possible that they don't comply with the role that we're requesting. So we have a condition which is mobilization. The greater the mobilization, then the lower the risks of the risk of not achieving the achievements, if we were to simplify. And it's quite clear, I believe, in international cooperation, for example. There's a lot, for example, I also come from civil society, so we need to mobilize the movement of human rights, as we call it in Argentina. But also there are other conditions to consider. Other conditions is, for example, that, and in Colombia, you've been doing it very well, it's to also achieve international pressure. International pressure in the best possible definition of the world, how to boost, how to strengthen, for example, domestic or national programs through a generous intervention of the international community that can create, let's say, this overarching safe space for these processes. And this is very much advanced in the case of Colombia, but perhaps there are other conditions that are not perhaps so advanced, and perhaps these more long-term processes on what is transition and what is transitional justice can certainly provide. And one of it is the need to have actors, innovative institutional actors that are quite strong, meaning those people beyond or on the other side of the shore. In this case, is the HEP. Sometimes we forget in the work that we do from the activism side, or those who create or exert international pressure, that it's necessary to identify and map the state. We need to know who, for example, as our colleague said in the beginning, I think if I'm not wrong, if it was Daniela, on, for example, what is the mistreatment that they've received in the ordinary justice. We need to know and map who are those that are more distance from our claims from the state, and those who are closer, and how we can work and strengthen. In the middle are those hybrid actors that perhaps have a state related career, an official that don't really favor or have an opposition to our claims. So it's necessary to identify them, because these are the actors, the institutional actors that will channel our claims and our fights, and that who will guarantee certain stability. And that is also, for example, that has not been, in my opinion, sufficiently observed within transitional justice, nor from the international cooperation that is in charge of, for example, institutional reform. But this is, I would say, a thinner topic, which is the need to see those innovative actors, institutional innovative actors, because they break the status quo that the institutional reform establishes. Because I can create a special jurisdiction for peace, right? But I need officials that can make it a reality in alignment with the objective of that institutional reform. And I think that this is quite lost in many analyses and discussions we have. And on the other hand, many times what we lose sight of as conditions, for example, are the capacities of determined actors to block these transitional processes. And many times we have a vision of incorporating, for example, that all or a very specific group does not want these objectives to achieved. And sometimes we forget and only think about the state. Okay, how can we make it so that the judge X can listen to us or the president of this commission can implement it? And we also need to work on that. We also need to work on those blocking agents, which many of the times are not the perpetrators that are accused. Let's not forget governments that promoted the truth, for example, in the case of Brazil, but were against the mechanisms of justice. So they become enablers of truth, but they interrupt at the same time, or rather block justice processes. So it's also clear that there is a need for this. So if we look about this question about the practices that can be learned, well, there are practices, and these are not political practices, rather conditions. How can we create conditions, greater social activism, greater international pressure, something that we already sort of know, but let's also consider how we can create a greater institutional innovation and how we can also consider or how we can weaken the blocking power. And just to close, clearly, if we want a long-lasting peace and if we want a human rights culture, we should not lose sight of the economic actors that are within the causes, consequences, and also the prelude of many of our most atrocious crimes. And this is not discourse related. We see that there are certain groups that have participated in the implementation of the terror 50 years ago, or in the Nazi Germany, are being judged in Brazil for crimes in Brazil, or in Argentina for crimes in Argentina. There is a legacy of impunity that certain economic actors are enjoying. So we need to also consider this. Thank you very much. All right, thank you, Professor Gabriel Pereira, for your very enriching intervention. I'd like to just mention the importance of these conditions that you've reiterated, or rather reiterate the conditions that you've pointed out that would contribute in some way to strengthen these processes of transitional justice specifically. Social mobilization, as you mentioned, is very important, as we know it in Colombia, also international pressure, which is also something that we work on permanently. And I think it's very important also, as you mentioned, this mapping of state actors with the objective to create greater impact on who those actors are. So I believe that these lessons and these conditions are quite important for our work. Now I'd like to hand the floor to Mr. Jairo Acosta. He is the attorney delegate with intervention coordination functions for the Special Jurisdiction for Peace at the Attorney General's office. So, Mr. Jairo Acosta, please take the floor. Thank you very much. Thank you for this very timely invitation in a context where I believe that we are being part of the response to this question, because we are here building a rule of law. We are being accountable, and of course we are redignifying these victims and all this national reconciliation process. I'll make an intervention based on some sources that have to do with experiences and paths, and this is from my personal experience, and it's because I was in the justice sector for 37 years, first as a judge and as a judge of criminal organizations, and afterwards as an ordinary judge, and then afterwards in coordination functions at the Attorney General's office. And after 28 years in academia, I would say that the first part of my life I've dedicated to teach the dogmas of criminal law, and then afterwards just restorative justice. And afterwards, I spent 14 years in transitional justice sphere, first as the special jurisdiction as an attorney delegate with intervention coordination functions for the special jurisdiction for peace of the Attorney General's office. So first, I'd like to clarify some ambivalences that my role could have had, or actually, I would say that we are just starting to walk this path. And these experiences assume to carry out evaluation of the validity of criminal justice, but also doing it in the realm of transitional justice. And of course, considering a question that wants to re-signify what is the state, or rather how to strengthen the rule of law. At the end of the 90s, I had the opportunity to process some judicial systems of pardon of the guerrilla M19, and the Statute of Rome was not enforced yet, but it said that only ferocious and barbaric acts amnesties should not be given because this was a political justice system or political transaction process. And I don't remember that any amnesties were denied. Actually, these were full amnesties. And of course, at that moment, this conflict with this specific guerrilla group was surpassed. However, the needs that the victims had was ultimately pending. And then I had the opportunity to be in the preparatory act of the law of justice and peace, in which there was another proposal for a reducal of sentences, which was very repairing. But at that moment of history, and these type of perpetrators, which at the moment was paramilitary members that received enormous resistance, and this basically was resulted in Act 975 for justice and peace. And it's interesting because it's a hybrid between retributive and restorative. I would say it's much more retributive, but it has some admin character, such as the victims law, and of course, of spaces in which victims could perhaps have, through reparation incidents, as we start seeing a very interesting spectrum in relation to the voices of victims. And finally, the special jurisdiction for peace, of which you all know much more than I do, because you are much more experts than I am in relation to this. So now retaking this question to talk about the strengthening of the rule of law under these conditions and experiences. Well, this supposes, firstly, to understand that the diagnosis that a transitional proposal could include or entail could be a transformation that was not, or sorry, a conflict that did not arise from one day to the next, but actually has very concurring elements, to be able to perhaps just deplete them with sentences or justice, temporal or short-term justice scenarios as just mentioned. Criminal justice has great challenges to overcome. But in transitional scenarios, even more. Firstly, it must stop being an exclusion justice where we exclude everyone. We exclude who we are sentencing, we exclude victims, we exclude whom we're persecuting, and the state itself is also excluded because it does not participate as a state or in representation of society. We'll make a short pause to say that the role that I've had in the last years in the transitional justice has had to do as a representative of society, representative of victims, of collective victims, and of victims that have not yet reached processes with a great amount of responsibility, and of course with the insufficiency of the input that we should have to be able to legitimize the voices of those who haven't been able to raise their voices. But to continue with this point, I'd like to say that the retributive response, very much in hand with the reflections of our indigenous judge that just presented, has just given reasons and samples, just to pinpoint some, that it had very little or not actually contributed nothing to the building of rule of law, that building of the state and the territory, of community acknowledgement and of legitimacy of authority is not real in certain territories, and it's not a reality, because sanctions or punitive elements have a punishment and consequence concepts that don't really transform. However, we have them here present in today's scenarios of transitional justice because we've identified these historically with non-impunity. When the agreements or the peace accord was signed with the FARC, the minimums of impunity will be reflected much more in the needs of repairing victims as of certain claims that are precisely those of truth, reparation, and guarantees of non-repetition. And I would like to emphasize on truth and on reparation, because these are elements that are not taken into account in ordinary or retributive justice of in national and international courts. And they are not taken into account because what's most foreign to a real purpose of truth is the confrontation, the vision of the adverse party. So one must say that many times these retributive processes are just a continuation of confrontation, this time in a scenario with very legal rules, game rules. So therefore, I consider that I think it's quite transcendent to take into account all national and international experiences here brought to indicate that a transitional justice not in the short term, but actually with much more inclusive methods, might achieve what is definitely transformative, which is firstly satisfaction of the rights and guarantees of victims, also the respect for the paths that are traced for those who leave arms to start responding for their crimes. And absolutely, I think it's vital to include society, include the community. When we were asking ourselves, and also when the father, the Ru, was asking, okay, where are we when he delivered the final report of the Truth Commission? He was just contextualizing by saying, we were not at that moment in which the model of the state that we had was claiming participation from us. Therefore, it's not possible that we consider ourselves to be a rule of law if we as a society do not effectively have not only a responsibility and a capacity of response, but also a real bet to the contribution of this transformation. It's not possible that we just leave transformation or the response to the tribunals in retributive or restorative terms when the dialogues are focused only and exclusively on the victims and perpetrators, when it's absolutely fundamental that the society and the civilians are part, that the perfect dialogic exercise that expresses a participative democracy can be exemplified in scenarios where we all, as parties, understand that we have commitments to peace build, because we did not do what we had to do at the moment when it was absolutely necessary, given the crimes and the atrocious events that happened.
And I say this because any sector that we ask where the state, the armed forces, justice, the civil society were at, as well as the economic society, then they will probably have many responses to give, given their omissions, and also because of this transformation. This is why, as part of the practices, by learning from what we did well and what we did not do, there are some activities that we still see in the special jurisdiction for peace that need to be considered based on what we saw or what we did not see in the absolute amnesty scenarios, which is precisely the transformation of the restorative transitional model through pedagogy or through interaction or through communication and through dialogue, because it's not about imposing concepts that are underway or under construction. When sometimes you hear about restorative focuses, you see that many of them allude to restorative practices that are not the essence of restorative justice, because they assume the presence of the victim, the perpetrator, and the state, conversing about what happened, about the transformations, and about the commitments adopted. This responsibility of perpetrators towards the truth and reparation cannot be in isolation. It has to be accompanied by those of them who accompany them on the world and see them and show them that this is transformational and that they should not stop doing it because they're dead. Their obligation is everlasting. This is why we believe that the construction of the rule of law and accountability go hand in hand It is precisely an absolute articulation of the perpetrator that affects the victim, of the community, and of the state. So I also need to make an emphasis on other aspects, which is how this restorative response or proposition is a transformational proposition that has to go hand in hand with each of the steps and phases that we made to the victims in terms of victims when we signed these agreements. It cannot be a sequence where there's first a fragment and then a reparation fragment and finally a conclusion fragment. I would say that it's very important to emphasize, first of all, on the diagnosis of the damage caused to the victims. And of course, these processes are going to leave many people without being repaired. But of course, the experience that justice and peace and other models leave us with is the collective focus. Collective focus in all senses, territories, ethnic groups, economic groups, and groups identified by their culture, all of them have to be characterized because this is where most damage was caused, and this is where we can make more progress and where we can create more transformation. It is therefore vital that we conduct a macro criminalization process without macro re-victimization, because the dialogue of these series of transformational propositions that go hand in hand with the purpose of reconciliation cannot leave scenarios to be built. And then these scenarios will have to consider that most victims were not the ones who were more empowered, but the ones that were more weakened when the conflict took place in their territories. And this is why we have a priority, the priority that is related to the proper approaches in the distinction of citizens with a specific need or with a specific condition that would offer them reparation as subjects to protection, and they need to be connected to the territory with the location and with the characterization of those that we haven't been able to reach and those that we need to reach. And secondly, as time goes by, we also see synergies going by. And this morning, somebody spoke about the role of judges. Of course, they play an important role in the sense of leading this process and guaranteeing that every step is exhausted and that they materialize the actions of truth and justice. But we need to differentiate the judges that on occasions need to exert responsibility of those that are not part of this synergy and this dialogue, to judge over these dialogues precisely to not confuse the different stakeholders involved. The judges that have this commitment of creating a harmonious impact and material impact on the process and to close this approach to the victims, the reparation processes, that is in the hands of the judges. And my time is running out, but we should not create false expectations over time, nor on the reparation actions. Pedagogy has to be very transparent in relation to something that we probably won't be able to attain, and that the economic expectations go hand with the transformation, and what the state needs to give to the perpetrators or to the parties will never be enough. But the north or the final outcome of this has to be symbolic and reparatory. Therefore, without a true understanding of the needs, then the proposals would not have any foundation. Thank you. Thank you, Dr. Jairo, for that wonderful presentation. Given our time constraints, I want to give the floor immediately to Dr. Mariana so that she can continue with her presentation and we can have some time left for the questions, because your presentations have been very interesting. Thank you. Mariana? Thank you very much, dear magistrate, and also to the panelists who are joining me in this interesting conversation. We are presenting different approaches and perspectives, and this makes this a truly wonderful panel. I am fortunate to be here with you. Thank you for the invitation. I wanted to comment about the question on the reconstruction of trust. What is the value or the contribution of transitional justice systems, but especially of HEP, to the reconstruction of trust in the rule of law and in institutions? And I think that you can start saying, as many of the other panelists have mentioned, we can start talking about the paradigm of restorative justice, because restorative justice presumes a justice that seeks the reconstruction of ties or bonds. This is a justice, as others mentioned before, it assumes a close and intimate justice that contributes to clarifying and to humanizing and to approaching and to rebuild ties and relationships. And in this sense, dialogue or the tool of dialogue is fundamental. Daniela, Jacqueline, Andronico mentioned this already. We need to speak up. We need to listen to each other. Just recently in the municipality of La Paz, a female leader who has suffered unimaginable situations, she said that the perpetrators in the ETCR, they are afraid of us. They do not leave those areas. They are afraid of us, and we are afraid of them. So what is going to be the contribution in terms of dialogue and discussions? We need to listen to each other. We need to speak up and listen to each other and speak up again. And this is a gigantic contribution. But the value of restorative justice is not just in the interpersonal and intersocial aspects. We also need to build trust and relationships with institutions, between the citizens and the rule of law, and citizens and institutions. And for this, I believe that there are several elements that I'm going to talk about, which are comments that we have mentioned that could contribute. You'll find many challenges that belong to transition scenarios where the challenges and the things that we need to do are gigantic. We have a titanic task in our hands. But since it's a transition that arises from a peace promise, then there's also a window of opportunity and proposes gigantic alternatives. So, in terms of what we can do, what we can think of, I think that, as the previous speaker mentioned, we need to consider the idea of cautiousness and modesty in what is being promised, because it's better to promise less and do more than what was promised at the beginning than promising more and not fulfilling that promise. Victims have suffered unimaginable pain. There are other programs that have done the same, and false promises would only cause additional damage that affect victims, individual or collective victims, and communities that shouldn't have suffered in the first instance and do not need to experience the consequences over and over again. In this sense, what are the tools that the system has to prevent these false expectations? I believe that one of the most important things would be integrality. This is a system that is created, an integral system. It's not just one single court or just a commission. It's not just a search unit, and it's not just a reparation program that was present for many years, and we know that that was not sufficient. But we need to create a comprehensive system with a series of mechanisms and a series of entities that can communicate between each other. And the final goal is that they can respond in a comprehensive way to the rights of the victims as possible. A proper articulation, as challenging as it may seem, because each of the entities is a separate universe and each of the entities has ambitious objectives as well. But in this comprehensiveness, we can find an important tool to prevent duplication of duties, or creating things that are already being undertaken by other entities or other instances. On the other hand, I wanted to mention that actually in the accord included what the success of this transitional justice system would rely on to have a broad acceptance by the society, which is to set the foundations for the restoration of trust. In that sense, the elements that contribute to the reconstruction of trust in the rule of law and in institutions are related to the fact that society needs to truly understand the errors of war. As Daniela and Andrónico said, we need to humanize this. We live far, the cities are far from the countryside. We are divided. We see each other as opposite parties. So if we can foster this empathy, then we will also be able to rebuild these relationships. But also, as we progress towards the proper response for the victims, and in the proper response to the rights of victims in an efficient and respectful manner and in a considerate manner. And I would also highlight another aspect. I would mention the importance for institutions to establish that the laws or that our legal system is applicable to everybody the same. There's nobody above the law. And I think that this could be particularly important for the jurisdiction because the question here would be, what is the gap in terms of justice that we are receiving once the final accord is signed? As my previous panelist mentioned, ordinary justice had not been giving a proper response to the rights of victims. They were coexisting with impunity, and this also created a scenario of mistrust with the institutions. So, what could be the greatest contribution to close this impunity gap? From HEP's side, because they are the judge of the system. So what is HEP's contribution in closing this impunity gap, and how by closing this gap we contribute to rebuilding trust and rebuilding relationships with the different entities? And here, it's important to remember what type of justice does HEP administer and how is it considered? Because when we think about restorative justice models, each of them are highly contextualized and specific and particular. In Colombia, for example, we started out from the premise and all the lessons left from justice and peace and the lessons drawn from outside, but by model and by design, HEP is concentrated on the responsible parties of the most severe crimes, and they focus on these parties responsible so that they can be imposed effective sanctions. So what does it mean, this contribution to the impunity gap in a scenario of peace building and in a scenario of restorative peace where we are chasing after effective sanctions? So what we see as a model in Colombia, which also attaches huge challenges, as we saw in the previous discussions, which is that these sanctions are for the highest responsible parties. Peace comes at a price, and we know this. We cannot understand jurisdiction outside the political agreement that creates it. We cannot understand the comprehensive system outside the peace process, which is what gave life to it. But then with these costs, we also have some commitments. And then we say, if this is a selective justice and we are going to concentrate on the responsible parties, then how can we make sure that this administration of justice is the most representative justice and that contributes the most to the responses to victims in terms of truth, in relation to that dimension, and in relation to that administration of justice? So the question about the effective sanctions, What the accord says is that these sanctions are going to include two components, and that these two components are of equal hierarchy, and that both are necessary to make sure that these sanctions are contributory sanctions to a closing of the gap and to look towards the future. One of them would be the retributory and the other one would be the restorative. What this says is that by design, the paradigm of restorative justice that we have been talking about that prioritizes dialogue is a model that incorporates principles and values that are also retributory, and both the retributory as well as the restorative aspects need to coexist at the time of designing, implementing the sanction itself. Retributory aspects, of course, is not being understood as imprisonment, and I think that we have great lessons to learn from the indigenous jurisdictions in the country who had been administering this type of justice for dozens of years. But in the retributory sense, we need to see it as the denial or the rejection of the crime, the denial of the superiority, and the possibility of reaffirming the equality of rights for all. There's nobody above the law here. And the role of justice, and the role especially of criminal justice, as restorative or transitional justice that it could be, which is still criminal justice, it is therefore vital. And I think that we need to think about how they're going to coexist and how we're going to understand them. What are the processes that are going to be undertaken to contribute to the reparation, how we are going to integrate the element in these sanctions, how we are going to integrate the element of search in these sanctions, but also how we are going to integrate the element of restriction to freedom and rights that are not going to be imprisonment. We're not talking about imprisonment, we're not talking about vengeance, we're not talking about eye for an eye. And the previous panelists have said that these models have not worked. But what can we think about that could work for the Colombian context in the reality of our country and in the realities of the different territories? So I also want to highlight the representativeness of justice, because if justice is not administered in the gap, justice speaks to victims, but criminal law is also a public law that speaks to society and that explains to all citizens that there were some crimes committed that we need to reject. And to be able to build towards the future and to reaffirm the rule of law, we all need to agree that these crimes against humanity cannot be called otherwise. And in this sense, the representativeness of justice also in a framework of selective justice is therefore key. It's key in terms of participation. Who is going to participate? How can I identify the victims? And how can I expand these participation spaces to incorporate and integrate key stakeholders in the territories? And how can I rely on the other tools or elements and mechanisms that we have in this comprehensive system that already was working? For example, the subjects of collective reparation, the groups that created the PIDETs, and a series of instances and mechanisms that could contribute to help to take over everything that is existing to expand these spaces for participation and achieve higher representativeness of justice so that it is administered correctly. And as a conclusion, we also need to consider that the peace accord and the implementation of the peace accord and the development and the administration of transitional justice takes place within a context where these societies and the victims' organizations have been strengthened, and that they are key partners to think about all these strategies and to think about all these methodologies. So there are dilemmas that are very complicated in terms of accreditation, the damage, as if sanctions responded to specific damages or collective damages, but that these tensions, and you talk to the different organizations and with victims organizations and territorial organizations, and you use this tool of restorative justice and of the dialogue that was mentioned in this panel, then maybe you can find the solutions to different issues that we find. Thank you very much.
Thank you very much, Mariana, for your presentation. It's very important what you've highlighted I believe that there are several topics that I would like to continue to talking about, specifically about this tension between the false expectations, modesty, and this together with the own expectations of victims, meaning how can or how sometimes it's very much used, this idea of, well, we will go out and level out victims for expectations for victims. And I think personally, we cannot level out expectations for victims. Victims have expectations that are, and I do agree, and that exist, and I do agree with this part that from the institutionally, we cannot foster these ideas. And this is a topic that we, if you'd like, we would continue talking about it and perhaps deep diving a bit on it together with Daniela and Jacqueline. There are several countries. To all, I'd like to mention that we have enabled a chat option where you can ask the questions. You can write your questions down. I apologize for not having said this at the beginning of the panel. There are questions that have been shared and other questions that come from the magistrates to all panelists here present. So I will read two questions. There's one question that is addressed to Daniela and Jacqueline. And the question says the following: what expectations do you have in the way in which, for example, the truth and reparation contributions to be done in relation to, for example, the non-selected appearing parties as maximum responsibles for the most representative and severe actions that constituted, for example, humanitarian crimes and war crimes in that room of judicial situation definition of the HEP. The question is done taking into account that it would be 90% of those who will appear before the HEP for the selected cases by the acknowledgement and truth and responsibility chamber and who will not be sanctioned. That is one of the questions shared. And another question that also shared by Gloria Medina, very much related to what has been shared, and it's about the possibility that certain scenarios are created for articulation so that there can be an indemnization or settlements to really be achieved without so many requirements, for example, technical methods, etc., for the victims of the country. And there's another question addressed to Mr. Heido. Mr. Heido, the question is the following: the General's Attorney's Office, as a representative of the society, since transitional justice has implemented. In relation to this, what proposals has this done, or what programs of reparation and social reintegration has it promoted or implemented so that in it all the appearing parties can be inscribed and allow them to have a life plan to avoid non-repetition and therefore satisfy victims? These are just some of the questions that we have. So there's one addressed to Jairo, and there are other questions addressed to Daniela and Jacqueline. So I'd like to hand the floor to you to respond. We are very limited on time, but I would like to just ask you to answer very briefly to these questions. Thank you. Well, I'd like to start, and I would like to do it briefly. I believe that this is a call to all the ones involved within the process, because although we saw that with, for example, the high commanders, for example, of the Central Joint Commanders, we had important advances in terms of their attitudes and the way that they perceived the situation. What actually happened in the process was that, well, that treatment, those meetings that occurred, those encounters that happened with them must also happen with the rest. Because something that I also mentioned in my in the day of the hearing was that, well, we all know that the guerrilla itself was not just the commanders, right? The guerrilla is composed by all those who were in the front lines, in the medium and most lower ranges. And most probably, they are the ones who had the possibility of sharing with our family members. And those are the ones who most probably have ways of actually giving us a truth that can perhaps provide to this restorative element of the process. Because we can see that there is sure a commitment from the commanders to talk to them, for example, for them to communicate with them and somehow help them raise awareness on what they are living and on what they accepted and decided to do as part of this process. But I think it goes beyond what they are told. Then we go back to the core point. This cathartical process must be done. We also need to pay attention to all those other appearing parties, and we need the resources, the mediums, and the ways so that we can have those spaces with them. Because this must be a win-win situation for all. Meaning they can give us something and we can give also something to them, be it tranquility, be it, or rather so that we can reach a common point where they don't feel judged for many things, but actually that they can understand that at this moment we feel actually more thankful for being able to heal what happened, and that they can also have this healing. So this job that we do with them is of utmost importance, and therefore I would also like to call and raise awareness on the spaces that must be created with the rest of the members. Thank you. Thank you very much, Daniela. I don't know if someone else would like to respond, Ms. Jacqueline. And then I'll give the floor to Mr. Jaime. Well, thank you. I do think that what's most important right now in this transitional justice is truth. And we must continue aiming towards that, to truth. As I mentioned just some time ago in my intervention, according to the work that has been done, there has been appearing parties that have contacted us. There are families that continue contacting us. And I think that these spaces, and we hope that this could be this special jurisdiction for peace time, it could be extended so that we can cover and engage with much more people involved in these crimes so that we can share these encounter spaces, especially seeking truth. I think that what didn't happen in the ordinary justice system is that they feared and that they were exposed to exemplary sentences, for example, in our cases of 54, even 74 years. And we're very much aware that having an exemplary sentence will not bring us back as our family members, right? But to be able to actually learn the truth, to be able to reconcile and be face to face, I think is actually the most important step, so that there is no repetition on these events. So I think that my contribution would be that this work should be allowed and should be enabled in the special jurisdiction for peace. And we would like to see obviously greater results, but as the cases are numerous, I just hope that we could extend the work that the special jurisdiction for peace has done. I acknowledge that this has been a marvelous work that magistrates have done to be able to know and learn the truth. Thank you. Mr. Jairo, I'll hand now the floor to you. And I just want to announce a question for whomever would like to take it. The question is, could you please make recommendations on harmonious recommendations between entities of the state to serve restorative expectations of the victims? So, Mr. Jairo, I'll hand the floor to you. Thank you, and thank you for the question. And hand in hand with this critical version of what have up until now been traditional topics, both in the ordinary justice as well as transitional justice, in relation to involving in this case demobilized and appearing parties, and also victims in processes that can reintegrate them, that can repair them. The General Attorney's Office, as you all know, to this extent, has had two different scenarios in peace and justice, not only as an intervening party, but also with an obligation to represent victims, indeterminate and collective victims, that therefore creates a very interesting space, which is to create reproposals and characterizations of collective damage that do not just restrict to the programs, the collective reparation and administrative reparation programs that the victims unit has, but it went beyond them so that they could have this restorative focus. It would involve then the appearing parties. That means that in different communities, when we carried this out, well, the diagnosis assumed not only to verify the characterization of why these were collective individuals, but why appearing parties and of course the state would provide transformative responses. At the end, there weren't so many positive responses because we always deemed the retributive component or the truth or consequences, but the spaces of interaction between some and others were very scarce, and among others, it has to do with the question that the magistrate just made. Because the state and the society itself, and we, of course, didn't push it much more. In the special jurisdiction for peace, I believe that the greatest challenge is to do it as of acknowledgement and as of need. Well, firstly, judicial safety of all appearing parties that has to do with their physical integrity and safety, with the exposure that most of the time they have, and also with certain life conditions, dignified life conditions, and also the general attorney's office and also the delegate for the follow-up of the court is continuously surveilling and creating reports so that these appearing parties can be provided with these minimums of dignity. And thirdly, the pedagogical effort that needs to be directed towards them acknowledging that the minimums of impunity that have been negotiated, and perhaps that for those appearing parties that are not appointed as maximum responsible ones, well, these assume obligations of truth and reparation, although these are not the same in terms of proportionality. And this cannot be done without any pedagogical effort. Unfortunately, some of them from both sides, for example, some public forces, appearing parties, as well as guerrilla members that are appearing parties, they believe that only and exclusively they will be object of persecution and sanction or investigation of sanction, only the responsible parties, and that they are therefore excluded from any type of obligation. And I don't understand this as such. I think that is precisely one of the great tasks of the Chamber of Investigation and definition of judicial situations, but without any pedagogical effort, without any understanding and commitment, that will not be done. And therefore, right now, I believe that the strong point of the work that we've done from the General Attorney's Office is specifically in representation of this judicial safety of these appearing parties and of all the different rights that victims also hold is a pedagogical effort and also an articulation. And I would just like to close by responding to the second question. Articulation assumes or supposes that the citizenship and the state and all involved institutions and with transformative vocation need to be interlinked in that space, meaning being able to create reparation actions based on, for example, a set of institutional proposals that not necessarily satisfy the needs of the victims, and also claim to the state that funds projects that are not necessarily sufficiently specific or planned with the sustainability steps. That will certainly hinder this to be a possibility. And I understand it like as such, and that is how I'm promoting it, that only concurring with all the different institutional stakeholders, the civil society, the victims, the appearing parties, and in representation to the society, that is how we can create truly transformative responses where all appearing parties have really clear what they can do for these victims from that awareness. Thank you very much, Mr. Jairo. I don't know if someone else would like to intervene to respond to the questions. We are very limited on time, but all right. It seems like it is not the case. It's now 12:37. This panel was supposed to end at 12:30, so I want to thank you all for your participation. And we've reached the end of the same. I think it was deeply enriching for our exercise in the special jurisdiction for peace. And I want to thank all our guests for sharing your experiences in this space and for contributing so significantly to our work. Thank you. And I want to excuse myself because I know that we've received more questions, but unfortunately, we do not have any time left. And I've just got a notification. We've need to close now. Thank you very much. Thank you, Magistrate Ana Manuela, for your moderation, and thank you to all panelists for your very important contributions to this conversation. And we want to highlight also the presence of Daniela and Jacqueline. Thank you very, very much for joining us. And also, how not to highlight all participants who have joined us from different regions of the world. We actually just received the report, the metrics, where it confirms that during these 2 last days of this international conference, we've connected through Facebook, YouTube, Zoom, and our platform almost 16,000 people who have shared with guests from Switzerland, Mexico, Mali, Guatemala, El Salvador, Spain, the US, Bosnia, Argentina, and Colombia. So to conclude this international conference and to provide space to the conclusions and recommendations, I'd like to hand the floor to Magistrate Danilo Rojas Betancourt of this section of Appealing of the HEP, who will provide these conclusions of this virtual encounter. Then we will have the work balance of the HEP by the president of our corporation, and then the projection of the following 2 years of the HEP, led by Magistrate Roberto Carlos Vidal, our future president. So please, hand the floor to Danilo. Magistrate Danilo. Well, I would like to highlight that the most important or appealing conclusion is the importance of this comparison exercise that we've done. Comparison exercise for many things, but especially comparison to reaffirm the presence of tragedy and pain. I think that this is a constant element that we've seen in this comparative exercise, and this reaffirms 2 values: the co-fraternity of the victims of all their requirements, also the solidarity with the victim that comes from they themselves, of the local community and the international community. And these values, I believe, impose then the following 3 things. 1, a moral duty with the victims, and also this morality that has been spontaneously constituted to a claim of judicial, social, economic, cultural, and environmental right. And these claims must be reflected by that moral burden that accompanies them in agreements and positive norms that can balance out peace requirements, taking not only into account the context, but also international standards of human rights. I think that it's not impossible to conclude that perhaps the most important conclusion is that we should constitute in the desideratum of our work of appealers as what we call transitional justice, be it as in the roles of commissioners, advisors, experts, judges, rapporteurs, representatives, or any other role with whom we describe a person that understands the responsibility of living in the most Popperian definition, and that this path can help victims of great atrocities.
The contributions from different practices conceived as transitional justice remedies are also notable, which propose the rereading of the current limits of the definition of the field or the redefinition of relations with other related fields. The debate was already raised at the time by Pablo de Grave. Gabriel Pereira also added to the issue of temporality of what we call transitional justice process. The case of Guatemala seems to be a good example, as well as the new forms of identification of damages and the reparation thereof proposed by the Chamber for the Recognition of Truth of the Special Jurisdiction for Peace in Colombia. But we can also include, especially for the redefinition of the relationships with other nearby agendas, the alert launched by Naomi Roth Ariasa on the corruption generated by the co-opting of the state by different illegal actors, especially at the local level. The examples of El Salvador and Mali also illustrate efforts and remedies other than strictly judicial ones, with 2 noticeable characteristics: the persistence of the victims and part of the civil society to not forget the atrocities committed, and the political difficulties in the midst of which the efforts of the institutions concerned are advancing: the Search Commission and the Truth Commission. The case of El Salvador also shows an important lesson about what should not be done, as well as what Amir said in his presentation about the case of the former Yugoslavia. First, the invisibility of the victims. That should not happen, nor the non-inclusion of gender perspective. This is an issue that the president of the Inter-American Human Rights Commission, Yulisa Mantilla, and Mr. Jairo Acosta insisted on the need to apply the standards established by the Inter-American human rights system. Then we have the issue of articulating the principles and practices of restorative justice. I think that this was the broadest debated topic in the panels today, especially in the first one. This articulation of the restorative practices with transitional justice of the type that is applied in Colombia. Just to use Fernando Travesi's expression, these are institutional or formal, and also talks about efforts that can be added to the institutional efforts. For example, he talked about the connections of the micro and macro levels of society. And we must remember that Karl Stauffer advocates for a more protagonist restorative justice with greater coverage. This theoretical discussion has enormous repercussions on our current needs at hand, especially for the cases of non-responsible parties. However, we need to learn more about the community trials in East Timor and gachachas in Rwanda, presented by Naomi and Fernando Travesi and Karl Stauffer. We also need to learn more about the procedures for restoring harmony. I want to refer to the wise words of Andrónico, a Wayu indigenous leader, where he mentioned that spirituality has a great value. In this restorative line, we see that many restorative practices in HEP have been led by the victims. Jacqueline Castillo highlighted the importance of the artistic and symbolic route throughout the comprehensive peace system due to its great restorative, reconciling, and transforming potential. Also, their fears have to be heard, as Jacqueline said, about certain reparation proposals which could be re-victimizing. Restorative justice contributes with forms and practices of comprehensive reparation that are very effective, from symbolic reparations, but also for the reconstruction of trust between citizens and the institutions, as Mariana mentioned. This justice model also challenges the standard understanding about what we know as sanctions. And therefore, we need to question this, as Fernando Travasi recalled. What are the recommendations? Listen, learning, and understanding for not repetition. That seems to be the main recommendation. I say this based on the different interesting experiences we try to remedy the serious damages caused to victims. However, I want to add additional recommendations to the academicians. The illustration and learning from the case studies suggests keeping this type of analysis. A notorious example of its pedagogical performance and source to take some good practices could be the parallels of remedies presented in cases such as the ones of East Timor by Patrick Burgess and Rwanda by Naomi. We also need to delve into the relationships of restorative justice. I think that this is the great academic challenge ahead of us, especially for the case of Colombia. We need to delve into these relationships of restorative justice and transitional justice measures, such as ones implemented in Colombia, including sanctions and custodial sentences. Karl Stauffer said a key word to explore this relationship more in depth, the general responsibility notion. He used the word responsibility, and I think that's a key important aspect for this relationship. To the operators of transitional justice. In relation to the critical comments by Daniela Arandia, it is necessary not just to not make victims invisible, but also to avoid re-victimization as much as possible. She experienced this herself when she talks about humanizing the transitional process that they're going through. I would just add, together with Marta Nussbaum, that humanizing is to acknowledge all of us in our weaknesses and fragilities. This means in what is truly human within us. We should not, this is another recommendation for those of us who are working on transitional justice. We should not focus on the sole self-representation and isolation of the work that each of us undertakes. As important, special, and unique as it may seem, the efforts made by colleagues and peers throughout the world deserve all the attention, understanding of their context, and support for their best success. Because after all, everyone is committed to the best possible remedy to alleviate the pain of victims. We need to make ourselves heard in all potential cases, especially in political scenarios, to highlight, among many things, that political agreements aimed in good faith at solving serious and mass human rights violations and breaches must not lose sight of the standards established by the international community, which are intended precisely to contribute to guaranteeing the rights of victims. Particularly for Colombia, I think that we have learned broadly from all these conversations in these 2 past days. We are imposed the need to keep the comprehensive system for peace active, even more so now that we would focus on the comprehensive reparation phase and reconciliation phase in the scenario of the special jurisdiction for peace. 3 issues mentioned by Carlos Beristain could serve as pillars for the expected reactivation. First, what was said and done by the Truth Commission on the case of extinction by the Patriotic Union, with a particular emphasis on the dignification work carried out in favor of the exiled persons. Also, what the Truth Commission and the Search Unit have done, precisely in relation to the roughly 100,000 Colombians who are still missing. Third, the story that is going to be told. It is clear that in this regard, the important topic of truth, people need to consider the work concluded by the Truth Commission and the efforts that the Search Unit for Persons Considered Disappeared continues to undertake, but also the work completed by the Center of Historical Memory, as well as the important findings made by the judges in the first transitional justice system that has been formally installed in Colombia, which is Justice and Peace, that Mr. Acosta mentioned. Perhaps a good starting point would be something that colleague Catalina Diaz mentioned, which is the judicial work of HEP, met the denialism that wanted to be implemented in Colombia in relation to extrajudicial executions or false positives by members of the Colombian military forces. I just want to thank you all for your participation as speakers, as participants, as panelists and colleagues, and for your effort for staying until this time in this session. To the Embassy of Switzerland for the financial and technical support, especially to Marilena Aleman and her team for the efforts put into the organization of this event. To the team at the HEPS presidency, Emanuel, Angelica, Diana, the communications team, especially Hernando and Care, Ana Maria Acosta, the international relations team at HEP, the technology team at HEP, and the engineers and everybody behind the scenes who make this magic of virtuality possible. To interpreting, Juan Camilo, Jennifer, including Jonathan, who listens to us from another dimension. To the interpretation team, our English and French interpreters, to Shalem and Santiago, who are offering us sign language interpretation, and to our master of ceremonies, of course, Clara Marcela, and to the entire production team led by Jorge Walteros and Jason. From now on, I invite you to hold the 3rd session in 2024 on transitional justice, and hopefully that can be in person. I hope that we can hold it in the last week of October 2024. Thank you very much.
Gracias, magistrado.
Thank you, dear magistrate, for your wonderful remarks, conclusions, and recommendations. Once again, we also want to thank the organizing team. So we are going to conclude with 2 remarks. First, the results of the work conducted by HEP by the president of our corporation, Magistrate Eduardo Cifuentes. Good afternoon. I don't have video. Sorry about this. We can see you now, Magistrate. Perfect. Good afternoon to you all. Once again, I want to greet the large audience that has joined us. I want to title my presentation, The Special Jurisdiction for Peace and its Contributions to the Field of Transitional Justice and towards the construction of a new criminal law. Because the conclusions of the work of HEP, I have presented it on 2 previous occasions as well as in this week. And the work of the different chambers and the sections. This required concentrating support resources, especially in the first instance course, and exhausting the selection and prioritization phase, and promote the self-determination process of conduct and behaviors and resolutions of conclusions, and in relation to the sanctions and reparation measures, as well as the preparation for the tedious work in defining the legal situation of the parties and establishing a robust restorative system based on the duty of implementing sustainable and productive processes under the state, and also the functional transformation by the executive secretariat and obtaining greater resources from the national budget and from international cooperation, because this path had already been started. But I want to start my presentation under that title, and I want to frame it within transitional dogmatic. In the pragmatic path, the budgetary, organizational, financial efforts, and the articulation of chambers, sections, and organizations, everything that is under my responsibility and with the support of all my colleagues and collaborators, I have been able to achieve, are focused on the implementation of the transitional justice project that is emerging and that I try to mention briefly in the text that I will submit to Magistrate Danilo Rojas, to whom I want to thank and congratulate for his dissertation. In other words, what we have done so far is based on the success of the transitional justice model that is being built in the jurisdiction every day. We have talked about the outcomes already. It wouldn't be fully understood or fully covered if we do not focus our attention on the inventory of efforts that make it up. And therefore, we are going to talk about the construction model. The first thing is that we need to understand the differences between ordinary and extraordinary. Transitional justice could be conceived as an exceptional justice, as it is foreseen for moments of political change, which of course do not happen on a daily basis. We need to highlight the exceptional nature of these transitional justice mechanisms. Maybe we could think that the justice that is applied in transitional moments, it's a degraded justice, or that it's not justice at all. And if we analyze the situation in depth, it should be, in my opinion, we should see that all sanctionatory justices would be exceptional in the sense that the law in a society is compliance with the law and not the violation thereof. For this reason, it is important to differentiate between the pretensions of justice and the transitional pretensions, because in this middle ground, we can find the interest for a stable peace that responds to the rights of victims, and so that the responsible parties are punished for their international crimes. Transitional justice mechanisms can be created in order to satisfy the interest of justice, and in this sense, the fight against impunity will be placed in the center of the discussion. On the one hand, the perspective focused on justice highlights the role of punishment and the need to appeal to human rights to substantiate the use of criminal sanctions. On the other hand, the logic that is based on the interest in transition appeals to a practical perspective related to the strengthening of institutions. This perspective emphasizes on these restorative justice mechanisms and the use of amnesty and forgiveness and pardon. Transitional justice should appeal to rules and procedures that allow it to achieve goals that are visible. Because too much of a high emphasis on justice, understood in terms of punishment, could actually put the construction of a stable democratic society at risk. But in this transition, we could also affect its legitimacy. To substantiate legitimacy, transitional justice cannot be a radical rupture from the past, but it should ensure a certain continuity within this discontinuity. The idea is to establish a precedent in the Anglo-Saxon model or the continental model, which focused on the fact that the political community, what they consider as being fair. In the context of normality, this does not represent too much of an issue because law and justice are considered to be legitimate and their decisions need to be abided by, despite the potential disagreements. The question that we need to ask ourselves would be the following: how can we guarantee the legitimacy of a justice system between normality and exception, between the past and the present? The response I have found it in HEP in the use of international sources to substantiate their decisions. And the rapporteurs of the peace accord, they were aware of that. But the special jurisdiction for peace is actually placed in that supra-legal moment in the adoption of legality, which allows it to abstain itself from analyzing the domestic rules that substantiate it. But HEP does not start in an empty legal world, but in a world where international criminal law serves as a basis for it. In this sense, we would have to try to approach this relationship of this transitional justice and the usefulness of law. The transitional effect acts in a process that seeks to produce social changes and ensuring the justice of a political transition, or at least setting the foundation so that this can be possible. Transitional justice needs to be responsible for a past of great violations against human rights or infractions against international humanitarian right that make the ordinary system insufficient to cover this. For this reason, we have appealed to a combination of mechanisms that allow them to achieve their objectives, considering that the determination of responsibility is just one of the main focuses of this field, and the role of justice turns out to be relevant in this sense. It could be administrative, civil, criminal, and others. But in the case of criminal justice, we need to weigh between the purposes of criminal law and the goals of transition. And we also need to analyze the capacity of the system to face the crimes in the system. This supposes considering elements such as selection, prioritization of cases, and macro investigations concentrated on the parties responsible.
Transicional se
A
caracteriza
transitional judge is characterized by having a political and educational and decisive perspective on justice. Their actions are determined by the objectives of transition and by the principles of transitional justice. The fundamental objective is non-repetition of crimes. And for this, the judge and the system must develop instruments that can guide to the achievement of such objective. The dialogical function of the process, then, must be centered, because what this is about is that there is acknowledgement on behalf of the perpetrator and the state of these crimes, as well as a collective, clear commitment of non-repetition. Judicial pardon, or the measures of own sanction and alternatives that are conditioned to the contribution for truth and the acknowledgement of responsibilities, must have as an object exactly victims to be acknowledged and their suffering to be acknowledged as well as their dignification, and the promise of not incurring ever again in these type of events. An acknowledgement of what occurred, and that the fact that what occurred shouldn't have occurred. The dialogue character of the proceedings strengthens the restorative principle of the judicial system, and therefore the interpretative horizon must be determined by these norms. The judge, when interpreting these norms, transitional norms, should ask themselves, what is that interpretation that best protects victims in the society on the one hand, and that can guarantee the social cohesion of the accused on the other hand? And for this reason, a logical law of application of the law must be built that goes beyond the normal law, taking into account, of course, that we're talking about an exceptional jurisdiction. Therefore, it is clear that the norms have not been able to foresee all circumstances because procedural dialogue acquires different connotations. The ordinary judges is characterized by a minor utility in the application of law because their context is a normal one, and therefore the submission to law is much more rigid. Aside from this, it has more detailed and precise norms. On the contrary, transitional judges must have an appreciation margin that is greater, very similar to the constitutional judge, because it should and must relax the application of norms if that is necessary to achieve the objectives of the system. Testimonials acquire also a significant value in transitional justice, not only because of the narration of horror, but also because it confronts us and perpetrators to that harm done. It shows us the need to face that past and to restore the bonds that have been broken and recover life projects. On this atrocities testimonies, many things can be said. One of the main points in all politics of transitional justice is reconciliations. This can be understood as mutual pardon of the different actors, but really this is a vision that does not recognize the role of victims to not remember and not remember. However, from another perspective, pardon and the promise or the guarantee of non-repetition constitute in itself political actions that go beyond the religious sphere. The confrontation with the past through justice has as an objective not only the acknowledgement and identification of the past, but also its understanding. This does not mean that this should be understood as a justification of what happened in the past, but rather as a reconciliation act with reality. In the context of transitional justice, reconciliation can be understood as the acceptance that each subject, community, or nation can make of its own reality, or of their own reality, meaning of the historical, social, cultural, and geographical conditions that determine their own existence. For Arendt, the acceptance of what happened does not suppose just submitting to its destination, but its destiny, but rather confronted to actually set foundations for non-repetition. For this to happen, we depend on a clarification process with a suffering past that can reveal the truth of what happened to be able to face it, and therefore obtain reconciliation with that past. Arendt calls this veracity. And this supposes an imaginary act of other possible worlds, ones in which the victimizing fact has not yet happened, meaning the victim was not this individual. And this imagination act does not only have effects for reparation, but also for the decision of transitional judges, inasmuch as they also make a narrative of what happened as part of the acknowledgement of the victim and of their dignification. In this way, with a dignifying narrative, we avoid resentment and to give through path to the suffering of the past. The narrative that tells us the atrocity of what happened can help us deep dive into the evil and take perpetrators to realize that what happened should not have happened. The possibility of introducing testimonies within a trial with independence, be it by direct witnesses or not, can contribute humanity to the trial and perhaps create justice between the perpetrator and their crime. Atrocities or perpetrators of atrocities have also a pedagogical effort because they not only tell what happened, but they become themselves a warning so that these events are not to be carried out again. And we must also insist on the dialogue character of the process. It's the nature of the procedure, and it recognizes that criminal justice do not have a realization in its own framework, as we can find in this one. Purposes such as retribution, prevention, and special prevention don't have enough space, because we're trying to build a dialogic space and restorative one in which the behaviors can really contribute to a building that can strengthen and restore democracy. This is a very difficult task, because this must be done within a framework of claims and criminal sanctions for those accountable parties of severe infractions of international humanitarian law. And these demanding claims require appropriate mechanisms to be able to answer and respond to phenomena of macro criminality. One of these mechanisms is the selection and prioritization, because if the objective of the sentence is to stabilize the normative expectations of behavior in a democratic society, then it should be enough to have a sanction and punitive effort to those most responsible to satisfy the victims and the society's claims. But to finish, it's not just necessary to punish a great number of people, to perhaps disseminate in the consciousness of the citizenship how rule of law must be dominant. But we need to also sanction those most responsible so that they can respond for having and feeding a death machine. It's not just it's to rather acknowledge who has most responsibility in these international crimes in the conflict of in the framework of the Colombian armed conflict. The dialogic character of the HIP allows us to reach the purposes of the system, and it also proposes a different perspective on the sanctions. Although this model does not match the classical perspectives of ordinary justice, it is possible to analyze it under the light of criminal laws such as DOS. I would just like to focus on this to the extent that we can show our contribution to a democratic model of criminal law. Criminal law, according to this author, is aimed at the participants of a political community. Certain behaviors are punished in as much as they affect the community as a whole, and therefore all are engaged and feel appealed. This space then belongs a space where the community expresses their rejection to that committed act, and they hope that the process party or prosecuted party can assume their responsibility, acknowledges the harm caused, and using criminal justice as a mechanism of expression sometimes as membership, this responsible party is therefore treated as a member and therefore as a subject that has obligations in relation to that community. One of the most fundamental points is that one of the modification of the status of the prosecuted party. This is that despite the equality studies of the different parties, well, at the moment that a sentence is charged, that will be a transformation of the status of that party, that not only that passes from being a citizen to a sentenced person, to whom the political community to whom this person belongs has expressed a censorship to this act committed, but has also manifested their wish of inclusion through a sentence or a sanction or a punishment that seeks to reincorporate this individual in the community. Because Jorge Luis Borges, the author, in one of his works, he talked about the encounter of two reasons, two logos, in a joint search for truth. In that effort, that truth was sought to be said, regardless of who was saying it, in transitional processes that are being carried out at the HEP. And before the HEP, we want to highlight the carrying out of dialogue between victims and perpetrators. The ultimate objective is not actually finding out the truth that in many times is actually known due to the work of the ordinary justice. It's actually that this truth is said, that there is an acknowledgement act of which all appearing parties visit that place of pain they caused, and they re-acknowledgement again before the victims. Dialogue has another objective, which is to complement the narratives shared by the different agents involved in what has happened. Contrary to the confrontation of different versions that are irreconcilable, that the judge might direct, which is the classical model and adversary model of ordinary justice, the dialogic model of the HEP does not pretend to say that one of the parties is right. It actually seeks a most comprehensible narrative of what happened that can complement narrations with all narratives of the parties involved in the conflict in the dialogic process. It assumes also an understanding of the complexity of the crimes and the context of violence, and this would exclude the traditional criminal justice models. The HEP therefore contributes to the creation of a procedural system of constant dialogue where all appearing parties must assume a collaboration attitude with the system, not only contributing truth, but also contributing to the programs of reparation to the victims. They have the opportunity to make observations to the versions and contributing the evidence necessary, and this will allow to advance in the determination of truth. But here, the dialogue has an important function, which is allowing appearing parties to advance into an acknowledgement that is genuine of their own responsibilities. And that is why the acknowledgement room distinguishes three different types of acknowledgement: factual, judicial, and restorative acknowledgement. Perhaps the most important ones are the first and the last one, because they respond to the needs of victims that want to know what happened, but also claim different explanations of why that happened, and very frequently for their names to be cleaned or their affected family members to preserve their honor and good name. The act of acknowledgement not only points out to dignifying victims and guaranteeing the right to truth, to justice, and to reparation, but also this becomes in a very special communication moment and exchange between the victims and between the perpetrator and their political will. It's not only a moment of telling facts or sharing them, it's rather a moment where they acknowledge themselves as a member of the community and where the community accepts that individual once again as part of it. And as accepting this acknowledgement, victims express their desire to once again accept the perpetrator, obviously within very specific demands of and claims of non-repetition. The investigation of patterns in systematized crimes is one of the focal points in the jurisdiction, acknowledging that much of what happened during the armed conflict constitutes crimes of the system implies to adopt categories and methodologies of investigation and criminal analysis that is capable of serving the specificities of these type of phenomena. This is part of this set of tools, prioritization and selection, that can allow the judge before quality and quantitative massive crimes, those that are most severe and most representative in their maximum responsible appearing parties. The need to understand these type of crimes that have been organized and committed by organizations and not necessarily by individuals, not that only by restructuring individuals, plans, and functioning structures of organization, of criminal organizations, it is possible to understand on the one hand side the relation that can exist between the different criminal acts patterns, and on the other hand, the role that different agents carried out with the objective of identifying who should be called as maximum responsible appearing parties. The context as a fundamental tool to understand what happened that claims to researchers an interdisciplinary perspective that is able to build comprehensive explanations on criminal phenomena and violent ones as well. The category itself of maximum responsibles is one in which we focus the claims of gravity or severity and representativity that are needed so that the transitional justice system can offer a moral and politically admissible management. And lastly, on sanctions and restorative elements. This establishes that the sanctions or punishments that the HEP establishes will have as main principles to satisfy the needs of victims and consolidate peace. And these should also have the best restorative function of that caused harm, always in relation with the degree of acknowledgement of truth and responsibility. This precept, constitutional precept, is especially clear in the case of own sanctions. As we've said, restorative justice is the paradigm that must rule the judicial acts of the HIP, and its effects must be able to be traced all along the procedure. The dialogic procedure of clarification of what happened is a clear example of the examples that rule this model, this justice model. However, it is in the determination of the sanction in which we've most analyzed the influence of the restorative justice model in the HIP. The retributive justice is therefore focused on the committed crime in the past to punish those accountable parties, but it ignores, or at least places in a second priority role, the precepts that the generic code can have on the victims and on the accused party or in the society. Restorative justice, on the contrary, without actually leaving aside what happened, which is the crime itself, focuses its interest not only now in the past, but in the future instead. It seeks with the process and with the sanctions pressed to promote the reconstruction or the rebuilding of the social tissue that has been broken by the crime, with the objective to restore community and promote the full reintegration, not only of the victim, but also of the perpetrator. Own sanctions, therefore, place emphasis in the restorative and reparation characteristics of all appearing parties. The design and the definition of these type of sanctions demand dialogic exercises and participative ones in which all appearing parties intervene, as well as victims' communities. This is what can guarantee that these are restorative sanctions indeed. As it has been shown here, the figure of the own sanction is a judicial innovation in several levels. Firstly, this shows that it is not only possible, but in some cases, it is actually preferable to actually apply the paradigm of restorative justice to severe crimes. And secondly, it reinvindicates the notion of punishment in which the reconstruction of social tissue and the reparation of harm is prevailed. We therefore can conclude that the work that has been developed up until now acquires a different sense in relation to a model, a transitional justice model always under development. Transitional justice cannot be developed without a very strategic perspective, given that the objective is to really guarantee non-repetition of those crimes committed within the framework of the armed conflict. This is supposed to organize all the work of the jurisdiction around this one objective. Thus, when we see and analyze what has been done in the last 5 years, we see that the most important axis of all the process up to the current moment are the justice trials and the acknowledgement chambers, because these can allow us to activate all the different skills of the jurisdiction through the different resolutions of conclusion of each of the 11 macro cases. The amnesty, pardon, and definition of judicial situations chambers, because these depurate the universe of all appearing parties in such a way that not only are we considering those that committed crimes, international crimes, that have a duty to repair victims, but that strategic perspective also allows us to see in the near future that in the horizon, there is the imposition of the first sanctions and its execution in a restorative key. Thus, we can contribute to the clarification of these broken bonds of the society, and that we can really reach this most desired peace. So I want to challenge you to finally install conditionality regimes and tell the country that all appearing parties have complied with their obligations with the system. And that is absolutely not minor words. The transitional justice model in Colombia is perhaps the most important one in the current world, and it seeks to articulate the questions that since many years ago, the transitional justice have been asking: how to satisfy the rights of victims to justice, the truth and reparation, and at the same time guarantee the inclusion of former or ex-combatants to the political community. Lastly, how can we establish an adequate balance between the pretensions of justice and the pretensions of transitional justice? With our work every day, we respond to those questions, and we go from the claims of transitional justice to the achievements of a transformative justice. The balance of the management of these last few years to which I referred to in the beginning of my intervention, is integrated by actions and policies that were aimed to accelerate the process of certain skills in chambers, basically combining the two vectors, truth and punishment, contributions to repair on the other, meaning a restorative system. Within the framework of the 11 macro cases, we install 11 platforms of patterns of criminality, accountable parties, victims, restorative policies, territories. Around these 11 macro cases, we will develop and deep dive much more into the task of developing and issuing resolutions of accusations, sentences, punishments, and judicial situations, all the latter applying a dialogic perspective. In these 11 macro cases, we will dialogue on the dialogic procedures and the narratives of appearing parties and victims. And without a doubt, this will be reconciliation, non-repetition, and refoundation spaces of a new society and of a new policy. That is exactly why this balance has a direct relationship with the model of transitional justice that I've tried to break down. In advancing in this balance, we've pursued to provide a long-lasting life to this model of justice, and that is why I request that we can audaciously advance and to stride forward in this direction, because it does make sense. And that is what is expected that we can achieve to really stabilize, or rather guarantee a long-standing peace. To close my intervention, I once again would like to thank Magistrate Danilo Rojas Betancourt, who led the execution of this second international conference, as well as the magistrates who participated, Heide Baldosea, Marcela Giraldo, and Alexandra Sandoval. And all of you, thank you for your commitment, your time, and your valuable work to carry out this event. Likewise, I'd like to thank all the different speakers who participated, providing their knowledge and experiences in different spaces of debate and reflection. Without a doubt, this conference, international conference, has been very much enriched by your interventions and reflections. And I'd like to especially wish success to Magistrate Roberto Vidal Lopez, who will very soon be appointed as president of the Special Jurisdiction for Peace, as well as the Magistrate Belkis Izquierdo, who will assume her role as VP. The commitment, knowledge, and wisdom that characterizes you are a guarantee so that the HEP can satisfactorily comply with the promise of dignification of victims and contribute to guaranteeing that atrocities of the armed conflict in the Colombian context will never occur again.
Thank you very much to the Swiss government for your support and your cooperation. Thank you all. Thank you very much, Magistrate Cifuentes. Precisely as you said, we want to give the floor to Magistrate Roberto Vidal, President-elect for the upcoming 2 years for HEP. Good afternoon to all participants who joined us today. First, I want to send special greetings to our President of the Judiciary, Magistrate Eduardo Cifuentes. And I also want to thank you. We want to show immense gratitude for the wonderful work that you have undertaken in this past 2 years. I want to greet the members of the Swiss Embassy in Colombia. Your cooperation has allowed the possibility of this event. My colleague, Magistrate Danilo Rojas, from the Appeals Unit, which is the soul of these sessions, and also the group of colleagues who have joined him. I want to thank the guest panelists as well, who have given us their knowledge about this comparative debate, and to the large number of participants who are following this session from all regions in Colombia and different areas in the world. Transitional justice in Colombia was designed under the strict observation of international law and domestic law. This framework sets several aspects at the same time. First, the acknowledgement of victims and their rights. And secondly, it authorizes the granting of the broadest amnesty possible on the crimes that could be subject to it. And at the same time, it orders the investigation and the sanction and indictment of the most serious crimes committed during conflict. This legal framework that was applied to HEP through the transitional justice exercises in Colombia are already part of the assumptions of the country to process any initiative, any peace initiative. The Colombian model for transitional justice was materialized not just in HEP, but as many of the panelists mentioned today, our transitional justice model is materialized in the comprehensive system for peace, which was created in item 5 of the Havana Agreement, trying to conciliate these mandates. For this, they created the Truth Commission that already concluded its duties, and the search unit of people deemed disappeared, and the special jurisdiction for peace, and the comprehensive reparation measures for the construction of peace, and the guarantees of non-repetition. This means that this is a set of several entities that play different roles but are overlapping as well, all aimed towards ensuring the transition of the country. This is also a comprehensive system that has been promoted. In the words of Gabriel Pereira, it has been driven by a vibrant civil society, especially victims and communities organizations in the territories, in a system that operates in the paradoxical Colombian context, where we have a strong democracy that coexists with several non-international armed conflicts. We also need to review the achievements and challenges of the model from the specific perspective of jurisdiction. In these almost 5 years of existence, we have been able to define the horizon for investigation of the most serious crimes committed during armed conflict. And we have identified the parties responsible. These are materialized in the 10 open cases and a concentration of investigation that will open up a new case in the future. Our challenge at the level of investigation is to be able to lead and conclude those proceedings within 10 years as established by the agreements. We are a jurisdiction that is subject to a strict timeline. We have implemented mass investigation processes, and we are aware of the human and technical resources required by these investigations and that we will find to conclude these proceedings. The peace accords granted, on the other hand, the broadest amnesty possible to the members of the former guerrilla forces and relinquishing criminal actions and pardon for other stakeholders. By observing due process and the judicial guarantees, the jurisdiction will have to offer those people the definition of their legal situation that allows them to complete their reintegration process back to society. And we need to do this massively and expeditiously. This is a second challenge of our jurisdiction, which is the granting, as I said, the mass and expedited concession and granting of amnesty, and the definition of the legal situation of thousands of perpetrators who were granted this broad amnesty arising from the agreements. So having said that, with the first resolution of conclusions, as a conclusion of the initial investigations, the jurisdiction now opens up the chapter of indictment of the parties responsible. The Colombian model has prioritized the search for acknowledgement by the former perpetrators, and we have achieved this in the majority of cases. In lower cases, we will have adversarial cases more closely to traditional criminal law with the accusations that have to be filed by the accusation chamber and the proceeding that would have to be followed with the chamber with lack of recognition of evidence. So now the parties responsible, they already acknowledged their responsibility. And with this, we will start the indictment through dialogical and restorative processes. This leads to one of the topics in this session, which are the sanctions under special jurisdiction. To implement this, we have created a restorative system where victims and their organizations have been participating in the identification of the damages. This system is built in collaboration between the jurisdiction for peace, the national government that has the legal and constitutional obligation of providing the resources and for setting out the projects where the sanctions will be implemented with the support and the monitoring of the Security Council of the United Nations based on the verification by the United Nations in Colombia. The challenge in this sense is to build projects that respond to the expectations of victims on the one hand, and that make up genuine sanctions where the perpetrators can contribute to reparation with restrictions of rights and freedoms. And finally, this model, this Colombian model, should establish dialogues with peace dialogues or peace initiatives promoted by the government at this moment. As Pablo de Grave warned, it's not about a mechanical implementation of the jurisdiction model of the special jurisdiction for peace into the new negotiation context. On the contrary, I think that HEP is part of a careful dialogue amongst the different branches of public power. It is actually about conceiving a new comprehensive system for peace, where several state entities, including and starting with the General Prosecutor's Office and ordinary justice, but also the control entities and the executive branch, and several entities of the state can then respond to the requirements of the transitions coming ahead. The special jurisdiction for peace has full commitment with the transition of Colombia towards peace. We will continue moving forward in complying with the purposes for which we were created under law and under the Constitution by contributing to the Colombian nation and to the international community with what we have learned so far about this combination between restorative justice and transitional justice to guarantee the rights of victims and to be able to overcome war definitely. Thank you very much. Thank you very much, Mr. Roberto Vidal, President-elect for HEP for the next 2 years. This is the conclusion of our international session. We have 113 participants from more than 18 countries, and I want to thank Mr. Danilo Rojas, the coordinator of this event, so that he can conclude the second international conference. Magistrate Danilo, the floor is yours. Thank you very much. First of all, I want to acknowledge that I forgot to mention something, because in my special greetings, I forgot to thank the rapporteurs team at HEP who were responsible, and they will continue being responsible for the memories of this event. Carolina Chavez, Jonathan Ramos, Diana Fuentes, Yona La Rota, coordinated by Lidia Lozano. I just wanted to thank all of you again for your participation in this event, for your efforts of staying this long in this session. And I want to remind you that in 2 years, we will be able to hold this event again, hopefully in person. Special greetings to you all. Thank you.